In the sale To set the retinue at liberty forthwith, register to communicate the operative portion of the order to Superintendent Prison Ballari, Central Prison for forthwith for compliance.
Pleasure. Much obliged. Lordships kindly. I mean, we permitted to take a look at that order.
Draft. You can have a look at that.
We'll communicate the,
I'll
Draft
just
order.
communicate that same thing to them. Let
Page-wise adjournments. List number 1, page number 1, number 2 and 3. Page number 4, number 4 and 5. Page number 5, number 7 and 8. Page number 6, number 9 and 10.
But directed to post the matter for final hearing.
for release. Non-filing of acknowledgement for having served copies of
We'll see that
bill memo, AGA.
once it is. So, you can see and then pass out.
Hmm.
Wait for some time, we'll see.
Page number 7, number 11 and 12. Page number 8, number 13. Page number 9, number 14. Page number 10, number 15 and 16.
I serial number
Number
16, my lords. I appeal for the petitioner. My lords, seeking for a short adjournment in the last date of
Requisition maintain compliance.
Has to go before the district court. Last time you said, okay,
please.
Page number 11,
Okay.
number 17 and 18. Page number 12, number 19 to 22.
So Lordships kindly, my lord, serial number 20, my lord. I appear for the appellant in these matters. My lord, arguing counsel is not keeping well. He's down with fever and throat infection, my lord. I request for a date next week, please, my lord. I've informed the other side.
Yes, set number 20 at the request of the London Council for the appellant. List.
Obliged.
APTCL. 22, APTCL.
22.
Yes, at the request, same one. Give dates.
Page number 13, number 23 to 25.
For dismissal. This we've already decided this. The further renewal will not make any difference. Listed for dismissal. Final hearing. Come on, final hearing. Yes. On the other side.
I appear for the respondent.
Yes.
Obliged.
List. List number 2, number 1, Srimati Sumati, yes.
Respondent statements.
CWC.
In a hotel from past 4 years, because there have been heavy money transactions on the day he left the home. When he received the call, he said he is in, he's coming literally back from Coimbatore. That is the native place of the response number 4 and 5. That is the hotel owners. In fact, some of the amount has been directly transferred to them through the acquaintances of the petitioner's son. Complaint was lodged on 13th Milots.
The averment is that when they called, he was free and he was in Coimbatore, not in anybody's custody. Merely because the address of the owners of the hotel where he was working is in Tamil Nadu, would not be a ground for habeas corpus. Anyway, if time is granted, we will ascertain.
Lots,
Two
there
weeks.
have been direct transaction lots through the friends of the petitioner's son to the respondent number 4 and 5. They have received the amount. Now they are denying lots and they have to be inquired lots to know the whereabouts of.
Okay, please. Let them take things.
What is the involvement of the fifth respondent?
Plus, both respondents, one is respondent.
And what is her involvement?
Hotel.
2 weeks. 2 weeks, no?
17th March. Proceedings number 2, Sri Ram Singh.
Okay, sir.
Remains, nothing remains. Which crime is registered?
Yes,
Yes, ma'am.
He's remanded to police custody.
Crime number.
77.
Crime number 77/2025,
Police.
registered on 24/2/2023
Before
to 2023, my lord.
25.
25, sorry.
Which
20.
police? Vartura.
Vartur Police Station.
Is filed. Seeking following. SPP. Advancement. State. Crime number 25.
Yes, sir.
On 24/2/2025. Which court has demanded the judicial justice. We have to say that. It is closed.
Number 3, Sri Jaisimha KP.
14/2.
I think it. There was some time. No?
Appellants and cross objection in this matter.
Which one?
Second list.
Second list.
You secure,
Yes, no, my lord.
you take.
Yes, yes.
We have perused the government's made in the petition. Where the SPP accept notice for responding to the report. Instructions. Within a period of 2 weeks.
Yes.
Counsel for the petition.
17th March. List number 3, for preliminary, December 1, Sri Anil Kumar R.
Hearing for petitioner. Start accommodation.
Same.
Like special notification from schools.
This has come by special orders.
When you want. When- Need it. Need it. All right, but.
Your file, please tell us when do you want it?
My lord, this is a student matter. I have filed a impleading application in this matter. I am a student. Because of this, her 1 year getting wasted, whole career is getting wasted, my lord. This early hearing may be done, my lord.
We are ready today also, but he is not there. Your petitioner counsel is.
Yes,
Yes.
last time he was telling that a single judge is has to go. Then your lordship has told that it is a specially ordered matter. Yes, my lord.
Yes. When the
Yes. it's done.
counsel is not available and he seeks time of 1 week. In view of the said submission, list after 1 week.
On date may be fixed, my lord.
He has to say, not even 10 days after.
10th March,
Much obliged, my lord.
number 2 for orders, Sri Narayan Swamiji.
Sworn statement.
Waiting service of
Yes, sir.
The child is taken away by fourth respondent. Fourth respondent. But they could not have taken away the child. It's a harsh act. But they could not have taken away the child from the custody of.
What was the complaint about? It appears there were earlier complaints as well. Earlier
Yes.
proceedings were there.
No, but whatever, the child was in care and custody of parent.
Biological parents.
Not either way, the child could not have been taken away. The procedure adopted by CWC, I don't think is right.
JJ.
80.
JJ, please.
Not only the child in need of care and custody could be taken away, not otherwise.
Hmm.
There is a complaint, they take it away.
Procedure in relation to-
Kindly see the powers of the committee, my lord, at 29.
Hmm.
The committee shall have the authority to dispose of cases for the care, protection, treatment, development, and rehabilitation of children in need of care and protection, as well as to provide for the basic needs protection. Not what is need of care and protection is defined,
Correct.
not at
In the
40,
definition.
yes, in the
Yes.
definition,
Hmm.
section 2, section 2:14.
Hmm.
Child in need of care and protection means a child who is found without any home or settled place of abode
Hmm.
and without any ostensible means of subsistence. Here the child was in the custody of somebody
Hmm.
who was taken care of, either a biological mother or
No, was
Of
there
course.
any complaint before the committee?
not.
What was the
There was one complaint.
What was the complaint?
Complaint is that she is not the biological mother, that the adoptive mother. Complaint.
That is an illegal adoption. That was the contention.
Illegal adoption is what the complaint was.
Ah.
But based on the complaint, the child was taken away is the allegation.
Yes.
Purchase.
Purchase ಮಾಡಿದ್ದಾರೆ ಅಂತ.
Hmm.
How you are taken
What
the
is the,
child?
what is the power to take the
How
child?
to take the child?
Power to take the
You
child.
can issue
Well,
notice, you can consider.
CWC government nominated body, sir. CWC
Yeah.
government
Ours,
nominated body.
Please, we are aware of that. Please tell us whether you've put the parents on notice. The persons who are in care of the child, have you put them on notice? Have you put them on notice?
ಕನ್ನಡ ಬರುತ್ತೆ.
No, we appear for the melody. He has not come to the office. I don't think how he appears here.
ಇಲ್ಲ,
Hello.
chairman, you are chairman of the. How you are taken the child?
ಸರ್ ಇದು ಮಗು
What law?
ಸರ್ ಚೇಂಜ್ ಆಕ್ಟ್ ಇದರಲ್ಲಿ ಮಗು ಪರ್ಚೇಸ್ ಆಗಿದೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಹೇಳಿ ಒಂದು ಹಿಂದೆ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ.
Correct.
ಆ ದೃಷ್ಟಿಯಿಂದ ಅದು ಬಯಾಲಜಿಕಲ್ ಮದರ್ನ ಕರೆಸೋ ಉದ್ದೇಶದಿಂದ ಅಲ್ಲಿ ತನಕ ಮಗು ಒಂದು ಸಿಸೆ ಇದು ಅಂಡರ್ ಇಲ್ಲಿ ಅನ್ನೋ ಉದ್ದೇಶದಿಂದ
ಯಾವ ಕಾನೂನದಲ್ಲಿ ತಗೊಂಡಿದ್ದೀರಾ? ಫೋನ್ ಎತ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಾ ನೀವು ಅಂತ ಕೇಳ್ತಾ ಇದೀವಿ.
ಸರ್ ಎತ್ಕೊಂಡು ಹೋಗಿ
ಆಯ್ತು, ಅವ್ರದಿಂದ ತಗೊಂಡಿರಲ್ಲ.
ಅವರೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು ಸರ್.
ಏನಂತ?
ಪೂಜಿತಾ ಮತ್ತೆ ಅವರ ತಂದೆ ತಾಯಿ
36.
ಬೇಡ ಅಂತ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕರ್ಕೊಂಡು ಬಂದಿದ್ರು ಸರ್.
ಬೇಡ ಅಂತ ಹೇಳ್ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಏನೊಂದು ಇದು ನೋಟಿಸ್ ಬಂದಿತ್ತಲ್ಲ ಯಾಕೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು
ಆಮೇಲೆ ನೀವು
ಬಂದಿದ್ರು.
ಮಗುನ್ ತಗೊಂಡ್ಬಿಟ್ರಾ?
ಆ ಮಗುನ ಈಗ ಬಯಾಲಜಿಕಲ್ ಮದರ್ ಅಲ್ಲ, ಈ ಕಡೆ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅವರು ಅಲ್ಲ ಅಂತ ಹೇಳ್ಕೊಂಡು ಮಗುನ ರೆಸ್ಕ್ಯೂ ಮಾಡೋ ಉದ್ದೇಶದಿಂದ ಒಂದು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಚಿಲ್ಡ್ರನ್ ಕೇರ್ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಅಲ್ಲಿ
ಪವರ್ ಅದು.
After the completion of the inquiry, if the committee is of the
Rescue
opinion that the
ಮಾಡ್ಬೋದು
said
ಅಂತ
child has no family or ostensible support or is in continued need, may send the child to a specialized adoption.
36 inquiry
36.
Section 36 ಓದಿದಿರಾ?
Sir,
ಚೇರ್ಮನ್ ಆಗ್ಲಿ ಏನೇನೋ ಮಾಡಿದ್ರೆ ಕಾನೂನು ಕೈಯಲ್ಲಿ ತಗೋತೀರಾ?
Sir, JJ Act 81 ಅಂಡರ್ಲಿ ಮಗು ಪರ್ಚೇಸ್ ಆಗಿದ್ದಾಗ ಆ ಮಗುನ ರೆಸ್ಕ್ಯೂ ಮಾಡಿ
ಪರ್ಚೇಸ್ ಆಗಿದೆ ಅಂತ inquiry ಆಗಿದೆಯಾ?
ಅವರೇ ಬರ್ಕೊಟ್ಟಿದ್ರು ಸರ್ 16/11/2022 ಅವರೇ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ರು ಸರ್ CH-3 ಮುಂದೆ.
ಕುಡಿಯಲ್ಲಿ
ಇದೆಲ್ಲ ಒಂದು ಕೋರ್ಟ್ ಪ್ರಕಾರ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಸರ್
81, they are punishable.
2 lakhs after ending over the baby. CS 2 lakhs and we have paid the
That is what.
cash to CS Seniority. Our statement sir Pujita.
ಗವರ್ನಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ.
Even if it is an illegal adoption, the penalty is punishment,
Yes.
not the taking away. The child is being looked after. There is no allegation. There is no allegation that the child is harmed. No such allegation.
Such allegation. Child was in the care and custody of some parent, then they cannot take. Either foster or.
For, you will be liable, probably found guilty, you will be liable for punishment. But that does not mean that the child has to be.
Yes, even if the mother claims that I have purchased the child was under the care and custody of somebody.
There's
So
no,
unless it is abandoned, they could not have acted.
If I may please, my lord. My lords, to understand the matter at hand, my lords, we need to understand from retrospectively from when this entire fiasco began. My lords. My lords, the first time the Child Welfare Committee approaches me is back in the year 2020. And this is present even in the FIR, my lords. If I may be permitted to read a portion of the FIR, my lords. Which is at page 43, my lords, which says, ಫಿರ್ಯಾದುದಾರರು ನೀಡಿದ ದೂರಿನ ಸಾರಾಂಶವೇನೆಂದರೆ ಮೈಸೂರು ನಗರ ಕೆಸಿ ಲೇಔಟ್ 11ನೇ ಮೇನ್ 7A ಕ್ರಾಸಿನಲ್ಲಿ ವಾಸವಾಗಿರುವ ರೂಪಾ ರಾಮ್ ಹಾಗೂ ಪೂಜಿತಾ ಜೆ ಎಂಬುವವರುಗಳು ಸುಮಾರು 6 ವರ್ಷದ ಮನಾಲಿ ಎಂಬ ಬಾಲಕಿಯನ್ನು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಸಾಕಿಕೊಂಡಿರುವ ಬಗ್ಗೆ 18/8/2020 ಮೊದಲ ಬಾರಿಗೆ ಮಕ್ಕಳ ಕಲ್ಯಾಣ ಸಮಿತಿಗೆ ದೂರು ಬಂದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಮಕ್ಕಳ ಕಲ್ಯಾಣ ಸಮಿತಿಯವರು ನೋಟಿಸ್ ನೀಡಿದ್ದು ಈ ನೋಟಿಸ್ಗೆ ಪ್ರತಿಯಾಗಿ ರೂಪಾರಾಮ್ ಹಾಗೂ ಪೂಜಿತಾ ಎಂಬವರು ಹಲವು ಕಾಲಾವಕಾಶಗಳ ನಂತರ ದಿನಾಂಕ 16/11/2022ರಲ್ಲಿ ಮಕ್ಕಳ ಕಲ್ಯಾಣ ಸಮಿತಿಗೆ ಮುಂದೆ ಹಾಜರಾಗಿತ್ತು. What happens now? What section 28 clause 4 rule 28 clause 4 of State Act states, my lords, within 4 months from the date of production of the child, my lords.
what rule are you referring to?
Rule 28 clause 4, my lords.
Of?
JJ rules, my lords. JJ Act rules, my lords. It states that from the date of production of child, my lords, within 4 months, the investigation has to be complete, my lords. Now, in this case at hand, my lords, there has been a series of procedural lapses, my lords. In the first time when the petitioner was brought before the PWC, it was told that after us providing all the scanning reports, and also my lord, on the last day of hearing, your lordship had requested me to produce the scanning reports during the time of pregnancy to establish my case, my lord. Now, initially, my lords, what the law states, my lord, the person interpreting certain offences against me, my lords, he has to first establish his case, my lords. But here in this matter, my lords, I am being incessantly put in a position where I have to defend my biological daughter, my lords, that I am the biological mother here, my lords. There is not a single shred of evidence that CWC is producing before the report, not in the course of that investigation, a single shred of evidence that the said daughter is not mine, my lords. No, I am not the biological daughter, my lords. This is the fact of record even to this day, my lords. I have been incriminated against, again, there are certain offenses incriminated against me, my lords, that are completely false. Point number one. Point number two. One second.
Just a moment. please.
They were the baby. Her baby one.
Better that he does not argue this case. As of now, we can ask the baby to be given back, but the baby, there must be frequent visits. The baby must be monitored and she must undertake to produce the child wherever required. Please, it is better that you don't argue further without understanding what is on record.
Can they take the child?
That they cannot. But then what if this is actually her statement? Then it is purchase itself. Just 1 minute. There must be a color.
No, see, they may not dispute that. He has appeared.
Yes, yes.
You appeared
same.
before CWC, no?
Yes,
You've given a statement.
no, when at the time when I was called in persons to summons in Annexure D, my lords, I was made to sign a empty sheet, my lords.
It is not
And
empty
after
sheet,
the-
it is in
Your
your,
handwriting.
it is in your own handwriting. Please, counsel, don't argue further. We might send it for forensic examination. The signature in the wakalat is yours. Same signature, same handwriting, the statement is made. The question is only whether they can take the child from your custody by. Please, counsel.
Yeah.
Crime is registered against you, mister. Don't argue like that. Stealing the child.
And that will reach its legitimate end. Please take it from us. If you're taking the child, you can take the child because they don't have the right to take the child from you at present because the child is not a child in need of care and protection. They don't have any contention as at present that you're ill-treating the child. But you will have to be under strict surveillance of the department. You should also undertake that you will produce the child wherever and whenever required.
He has to file affidavit.
An affidavit has to be filed here because this is in writing. You agree on all of this. Whether they can take the child away is the only question we are considering here. They cannot. Going by the provisions of the Act, there is no provision to take a child who is in proper custody, who is not harmed. That is all there is to it. Everything else appears to be loaded against you. So we will not go into any of that. Please don't argue on merits because then it will create difficulties for you also. The question is this: you don't have the power going by the provisions of the Act to seize a child and take it away. You can take action against them. 80, what does 80 say? What does section 80 say? They're liable for punishment, not seizure of the child. The child is not some kind of a chattel or stolen goods to be seized. What is your primary responsibility, mister? It is to see the welfare of the child. If the child is not harmed, then you must take care to see that the child is not further harmed. You cannot take a child from a home where the child is being looked after and put it in a care home unless the child there is some imminent threat to the child, the life of the child. You cannot do this. It may be true that there is a case against the adoptive parents or whatever, not adoptive, whatever you call them. You can take action in accordance with law, not otherwise. Where is the provision which says that you can take a child who is in a house properly taken care of? You don't have a case that the mother harmed the child. No such contention. The person in custody has not harmed the child. You can take necessary action in accordance with section 80. Section 80 does not say that you can take away the child.
ಒಂದು NCPCR ನ್ಯಾಷನಲ್ ಚೈಲ್ಡ್ ರೈಟ್ಸ್ ಕಮಿಷನ್ ಒಂದು ಆರ್ಡರ್ನೇ ಫ್ರಾಡ್ ಮಾಡಿ ನಮಗೆ ಕೊಟ್ಟು ಅದ್ರ ಪ್ರಕಾರ ನಮಗೆ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ದಾರೆ.
Where does it say?
Broadly created and
even then you can take action for punishment.
Register another case for that.
Yes.
Created.
For creating documents, all that you can do. Nothing stands in the way. But only question is, if the child is not a child in need of care and protection, can you take away the child? Term of imprisonment shall not be less than 3 years. If there is any document that you have created, that also will have to be looked into.
Duplicate of it is the next one. That is the original.
Created one.
Yes, sir. Next one.
First one is the.
First one is the original.
Ikkada, sir.
The blue one is.
Blue one is created.
Created, sir. Created.
How you come from this created and
First one ಆರ್ಡರ್ ಇದೆ ಸರ್.
ಏನಂತ ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ
Difference.
ಹೌದು ಸರ್, ಅಲ್ಲಿಂದ ಒರಿಜಿನಲ್ ಅಂತ ತರ್ಸ್ಕೊಂಡಿರುತ್ತೆ ಸರ್. NCPCR ಇಂದ ಮತ್ತೆ ತರ್ಸ್ಕೊಂಡಿರುತ್ತೆ ಸರ್. ಅವ್ರ ಆರ್ಡರ್ ಕೊಟ್ಟಾಗ NCPCR ಗೆ ಅದ್ರ ಬಗ್ಗೆ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಗಳಿಗೆ ತರ್ಸ್ಕೊಂಡಿರುತ್ತೆ.
Declaration that they are a biological father. That's it. ಏನ್ ಮಾಡಿದಾರ ಮತ್ತೆ ಇದ್ರ ಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಬುಕ್ ಮಾಡಿಲ್ಲ ಅವ್ರ ಮೇಲೆ.
ಸರ್ ಅವ್ರು ಬರ್ದಿದಾರ ಸರ್, ಇನ್ನೂ ಮಾಡಿಲ್ಲ ಸರ್.
ಅವ್ರಾಯ್ತು, ನೀವು ಮಾಡ್ಬೇಕಲ್ಲ.
ಮಾಡ್ಬೇಕು.
What is happening, mister?
Unless all that is correct, we understand. You can proceed against the adoptive parents for all these, whatever is a crime, you can proceed. But still, the act does not provide
Further,
taking custody.
non-submission is,
One second,
non-submission.
one second.
Hmm. 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 Who's a child produced before? Child in need of care. Who's found without any settled place or abode, found working in contravention, resides with a person who's a guardian or otherwise, who is injured, exploited, abused, only a child in need of care can be taken custody of. This will not come within child in need of care and protection. Unless there is a contention that the adoption is too perfect. There is no such contention. Will not come. It is not finishing of the genesis of the child. Yeah, for the custody case of the child. If the child is being taken care of, we need to keep away all our moral ideas, because the child is safe. As long as the child is safe, they cannot touch it. It's not for, the adult society that the act is there. It is for the protection of the child. If the child is safe, and if there is no allegation that the child is being harmed,
The child is in the custody, who does not have authority.
that it will make no difference.
Who does not have
Will not make a
ability to
difference.
take care of.
That is the point. There is somebody who is willing to take care of the child. That their
Likely to abuse or-
moral and criminal antecedents may not be to our liking, but the child is taken care of. It is a child-centric law. We must look at it from the child's point of view.
Stolen child or illegally.
The basic thing is that the JJ Act is a child-centric law.
Yes,
Everything must be seen from the child's
from the
perspective.
child's point of view,
If the child is safe, wherever it is.
wherever it is.
in
Even
whose
stolen,
or
or-
else
yes,
custody, you cannot take custody of it. It is not our moral righteousness that is under question here. It is the interest of the child, nothing else. That is the basic provision of the JJ Act. If the child is safe in a home, it can be anybody. The moral standards of the person who's in custody of the child is not the question. The question is the child safe? Is the child happy? If that is so, you cannot take custody. You can take action against them for everything else. Custody you cannot take. It is only if there is the child who resides with a person, whether guardian of the child or not, and such person has injured, exploited, abused or neglected the child.
yes,
Only in such circumstances can you take custody, not
as
others.
your lordship rightly said,
But see,
Hmm.
it's one part.
Hmm.
That we are to such a
Definitely.
of forced document and
Definitely,
frustrating and
definitely,
arresting
that is,
care of the child.
that again is the issue, because it is not about what we feel or about, it is only about the interest of the child. There is a specific provision which says that in general principles be followed.
there was a complaint and a seizure, like a commodity.
Yes, yes, it is not a commodity, it is not our moral canvas that we have to look into. Right to privacy, institution, positive measures. Presumption of innocence, participation, best interest, family responsibility.
Lord, 14 would clearly say,
Hmm.
who's found without any home or settled place.
Hmm.
So therefore, it can't go beyond that, because that is what the definition of child in need and care. So therefore,
Principle of non-waiver of rights. 3(9) says no waiver of any right of the child is permissible or valid, whether sought by the child or person acting on behalf of the child or a board or committee, and any non-exercise of a fundamental right shall not amount to waiver.
yes,
Therefore, the child has a right to the family.
yes,
We have to look at this entire exercise only from the point of view of the child. The person in custody may be a bad person,
yes, Lord,
immoral person.
yes,
Forget all that. What is the interest of the child? At present, not in the home. There is a
Yeah.
lady who's willing to look after the child as its mother. You can take action against the mother for whatever crime she has committed. And once it is established that the crime has been committed, the consequences will flow. But whether the child can be taken back, to where are we taking the child? From a home where it has a mother and a father who are willing to look after it, to a foster home or a government home. That is not what is intended by the act.
These people
You
are.
as a president of a CWC should understand that. Whoever is the president or whoever is a functionary of the CWC should understand that we are not on the moral policing side of it at all. She may be a bad person. She may have done whatever she has done with very bad, completely bad intents. Still, she has not harmed the child. It is the interest of the child that we have to protect.
For the sake of child, she has committed all that.
There is no complaint that it is for trafficking. That if that is there, that is
Yes,
completely
that-
different situation altogether. If the child is purchased for trafficking, then immediately you have the right. You have the right to take away the child, not otherwise. If you don't have a contention that she is trafficking the child or abusing the child or neglecting the child, you cannot take the child. We should not go by what the act, the words of the law say. You should go by what is the interest of the child. That is the basic principle of this entire exercise. That is why we have a JJR. A child which is taken care of by whoever. You're saying that is somebody who has purchased the child. You don't have a case that the child is purchased for the purpose of trafficking. You don't have a case that the child is harmed by it. We can't take a child out of a place where her best interests were saved and put her in a place where she's unhappy. We don't have that right.
Submissions. ಮಗುದು ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಪದೇ ಪದೇ ಬರ್ತಾನೆ ಇದೆ. ಚೈಲ್ಡ್ ಲೈನ್ಗೆ ಮಂಜೂರು ನೈಟ್ಗೆ ಪದೇ ಪದೇ ಕಂಡು ಬರ್ತದೆ, ಮಗುನ ಅಬ್ಯೂಸ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅಂತೇಳಿ. ಮಗು ಮನೆಗೆ ನಾವು ಭೇಟಿ ಮಾಡಿದಾಗ ಮೈಸೂರಲ್ಲಿ ಮನೆ ಇದೆ, ಅಲ್ಲಿ ಅಜ್ಜಿ ತಾತ ಇದ್ದಾರೆ, ತಾಯಿ ವಾಸ ಇರೋದು ಬೆಂಗಳೂರಲ್ಲಿ. ಮದುವೆ ಆಗಿಲ್ಲ ಇವರು, ಅವರು ಮದುವೆ ಆಗಿದೆ ಅಂತ ನಮ್ಮ ಜೊತೆ ಹೇಳಿದ್ರೆ ಈ ಕೇಸಲ್ಲಿ ಮದುವೆ ಆಗಿಲ್ಲ, ಲಿವಿಂಗ್ ಟುಗೆದರ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರು ಇರೋದು ಬೇರೆ. ಅವರು ನನ್ನ ಮಗು ನಮ್ಮ ಮುಂದೆ ನಮ್ಮ ಮಗು ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಅವ್ರ ತಂದೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ ಅವರು. ಇವರು ಬೆಂಗಳೂರಲ್ಲಿ ವಾಸ ಇದ್ರೆ ಮಗು ನೋಡ್ಕೊತಾ ಇಲ್ಲ. ಅಜ್ಜಿ ತಾತ ಇದ್ರೆ ಅಜ್ಜಿ ತಾತನು ಮಗು ನೋಡ್ಕೊತಿಲ್ಲ, ನೋಡ್ಕೊತಿರೋದು ಮನೆ ಕೆಲಸದವಳು ಗಾಯತ್ರಿ ಅಂತ ಹೇಳಿ. ಮನೆ ಕೆಲಸದವಳು ಗಾಯತ್ರಿ ಅಂತ ಹೇಳಿ ಮಗು ನೋಡ್ಕೊತಾನೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಮಗು ಅಲ್ಲಿದ್ರೆ ಮಗುಗೆ ತೊಂದರೆ ಇದೆ ಅನ್ನೋ ಕಾರಣದಿಂದ ನಾವು ಮಗುನ ರೆಸ್ಕ್ಯೂ ಮಾಡಿರೋದು ಸರ್.
No, has any of this been placed on record? What you're saying now?
ಇದರ ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ ಸಮಯ.
Have you recorded such a finding?
ಮನೆಗೆ ಹೋಗಿದ್ದು ಏನು ಅಬ್ಸರ್ವೇಷನ್ ಇದೆ?
ಅದೇ ಸಮಯ ಇದು ಫರ್ದರ್ ಸಬ್ಮಿಷನ್ ಅಂದ್ರೆ ಇದ್ರದ್ದು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ 16/4/2018.
Never mind about the technicalities. Is the child in danger?
ತೊಂದರೆ ಇದೆ ಅಂತ ನೀವು ಅಬ್ಸರ್ವೇಷನ್ ಎಲ್ಲಿ ಮಾಡಿದಿರಾ ತೋರಿಸಿದ್ದು ಓದಿ. ಯಾವತ್ತು ಹೋದ್ರಾ, ಏನು ಅಬ್ಸರ್ವೇಷನ್?
ಯಾವಾಗ ಕಂಪ್ಲೇಂಟ್ ಬಂತು, ಯಾವಾಗ ಎನ್ಕ್ವೈರಿ ಮಾಡಿದ್ರ?
But then if the child is not in danger, no
Let
penalty
them
to
file that
touch it.
statement.
That is so.
Then it is there, then we can concern.
Lord, we will
Yes, yes.
look into the records.
Yes.
Because even I have not seen the records.
Then ನೋಡಿ ಹೇಳ್ತೀರಾ?
ಏನಾಗುತ್ತೆ?
ಇರ್ತೀರಲ್ಲ, SPP ಅವ್ರು ನೋಡಿ ಹೇಳಿ.
ನಿಮ್ಗೆ ಓಕೆ ಅಂದ್ರೆ
Yes,
I mean,
because
speaking.
tomorrow we don't,
We don't.
today is a Friday, we can't have it tomorrow. 2:30. The
ನೆಕ್ಸ್ಟ್ ವೀಕ್
situation of a child, if the child is in danger, what they are saying is correct,
ಎಲ್ಲಿದೆ
but
ಇವಾಗ?
there must be, it
The
must
finding
not
was-
be just said.
ಮಗು
must be
ನಮ್ದು
recorded.
ಸ್ಪೆಷಲ್ ಅಡಾಪ್ಷನ್ ಹೋಮ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಇಲ್ಲದ?
ಛಾಯಾದೇವಿ ಸ್ಪೆಷಲ್ ಅಡಾಪ್ಷನ್ ಹೋಮ್ ಅಂತ ಹೇಳಿ ಮೈಸೂರು ಸರ್. ಮಗುಗೆ 7 years ಸರ್ ಇವಾಗ.
A 7-year child, imagine.
Yes.
ಸ್ಪೆಷಲ್
why-
ಅಡಾಪ್ಷನ್
that's
ಹೋಮ್
all.
ಅಲ್ಲಿ ಬಿಲೋ 7 years ಮಕ್ಕಳನ್ನೇ ಅಲ್ಲಿ ಇರ್ಸೋದು.
If I may please, my lord.
Monday.
30
Yes.
to 20.
You have done all what is not required, right?
He says Monday, my lord.
2:30, 2:30 over the weekend.
Papers only.
If as a matter of fact, there is no such finding,
Yes.
then let the child go to
Yes,
the
yes.
mother for the weekend and
Yes.
come back. We'll direct the production of the child.
Yes.
Read the paper.
Yes, I'll read.
Take briefing from me, but then make
Yes.
The examinations are on.
Don't worry about that. Yes,
And the baby.
please don't worry about that. You are now,
I don't read.
the parents' patria has taken over. Don't worry, we'll see what can be done. Yes, please tell us 2:30. Yes,
There is a
please be
petition.
here.
Huh?
Hmm. Hmm, hmm.
2:30 in chambers, Pidappa. New money. New money.
Yes.
You'll give the petition also for that.
List number 1. Number 2 for admission. The Abhinav Ramanand.
Yesterday's retail petroleum outlet. Yes.
There are three categories. Group 1, Group 2 and Group 3.
Yes.
Group 1 is where they are the owner of the land or registered deeds for more than 19 years.
Yes.
Group 2 is wherever they have the registered the sale agreements. Group 3 is whether they don't have the land, but they say that if there are no one in the Group 1 and Group 2, then they will come under the Group 3. My learned friend was referring to page number 39, where it says that one more opportunity has to be given. I'll just read the note 2, page number 39. That is not applicable in this case, I'll explain mine. In case of the location where the applicant has not offered the land in the application Group 3, or if the offered land of all applicants under Group 1, Group 2 got rejected due to not meeting the date of applicant, then all such applicants shall be given an opportunity to offer land or alternate land in the advertised location space, provided the applicant is all other eligible criteria. If the persons who are there in the Group 1 and Group 2, if all of them fail, then only these clauses will apply.
What is your contention with, on facts with regard to this?
On by conventional at this, that's admittedly they said mortgage. We only take where they have the ownership or the registered sale agreement. So mortgage deeds are not considered by us. And one more contention is that it's an agricultural land. We cannot take the agricultural land for the establishment of the petrol pump. These are the only two contentions.
There are 3 applicants in Group 1,
Please,
9 applicants in Group 2,
correct.
and 17 applicants in Group 3 for this location.
Correct.
Hence petitioner cannot, therefore your contention is that because there are 2 other applicants in Group 1 who have the,
He is placed from Group 1 to Group 3. We are not rejected. It's only from placing him from Group 1 to Group 3. Now we will evaluate other 2 applicants who are there in the Group 1. If they are also not eligible, then we will come to Group 2. If we will verify all the documents of Group 2 candidates. If then also they are not eligible, then all of them in the Group 3, even he will get the chance to give the alternate.
what do you say?
Page number 27. All that they will say is mortgage has been published for the land offered in the application. And it does not fall under Group 1 as per clause 4, 5 of the order. That is all that they will say. Please take this.
In view of the above, we regret to inform you that your candidature has been found ineligible. However, your candidature may get considered for selection along with Group 3 applicants as per guidelines. So that is what they say. Yes.
So please come to my lord, page 36. First thing is, my lord, if they are justified in rejection, my lord, all this will, my lord, come out for consideration. If the rejection itself, my lord, is not as per the, but please see, page 36, my lord, gets, my lord, Roman 5. Now, my lord, please turn over to the next page, 37. Please see clause B, applicants under group 1 should have documents to establish ownership of land offered from the dealership as on the date of application, such as, please see, my lord, fourth clause is that any other type of ownership or transfer deed document. So assuming, my lord, it is a mortgage deed, not a lease deed as they are trying to make out. So I fulfill this criteria because it says any transfer deed. So mortgage admitted is a transfer, form of transfer of property. So what is it that they are looking at? They are looking at not my control over the land to set up a retail outlet. That is all that they are concerned with.
Ownership of land offered for the
Yes,
dealership.
Transfer deed document. So therefore, not any deed which falls within the Transfer of Property Act, is a transfer deed document. So why is it that they are excluding a mortgage deed, Lord? But if they are willing to accept lease deed as a not means of document by virtue of which I can establish a retail outlet, but same analogy would apply to the mortgage deed also. There only criteria or requirement is not, it should be above 19 years, by document immediately is above 19 years. Is in this context, Lord, I am saying that one opportunity could have been given. Please, you know, Lord, page 40. It is in this context I am saying, Lord, one opportunity should be given because after, Lord, I am declared as a successful candidate. Lord, this they can easily, Lord, try to pick, Lord, some argument. You need to see that the selection process is, Lord, not taken as per the stipulations contained in the document. They would simply say a document is not eligible, you will put into group 3. That is not, Lord, the purport of the document. Please see now page 40, Lord, in this background. Page 40. Only one opportunity would be given to the applicant. Either for offering land, if the applicant has not offered land along with the application form, or for offering alternative land, if the land offered by the applicant is found to be not meeting the laid down criteria to scrutiny, land evaluation, rejection of land after selection. So therefore, Lord, this is the one opportunity that I am talking about. Otherwise, Lord, they will simply, Lord, this entire selection process will become a farce.
This is under noting.
Previous paragraphs. Based on the last.
Applicants failed to offer
Only to class 3.
Yes, and yes, exactly. Note 2, for note 2, they all the applicants are.
Why do they say that the mortgage deed cannot be taken into consideration? That is what they will have to explain. Rest of the arguments is consequent to their satisfying this court that a mortgage deed is not an acceptable deed. But if I offer a lease deed, what they will say is under section 5 of the Karnataka land reform that lease is far. But this is why I get submission because they make these rules or criteria pan India. Now let's say it is not converted. Let them show that one stipulation which says I must offer converted land. Now it suits their convenience to come up with all these things. But they should be more specific if they want to reject it. And I have produced an instance whereby on a very earlier occasion, they have approved a lease deed.
Where is that?
I've given that instance.
There is no dispute about that. I can put it on the affidavit that lease deed are considered as in.
Lease deed of agricultural land.
Not agriculture. Not the, it's a converted land. These cannot be given in the agricultural land, section 5, there's a bar. So hence, lease deed cannot be executed in an agricultural land. Hence, we reject if it's an agricultural land. If it's converted on that day, we take.
But please see, annexure, my lord, H, where they have given, my lord, the dealership to one Mr. Tarif. Annexure H. The document, my lord, which they have accepted, is a register, my lord, lease deed of an agricultural land, which have produced the page number 93. That is what I'm saying, my lord, total arbitrariness. When it suits them, my lord, they will accept this document. When they want to, my lord, not accept me, my lord, but accept somebody else, they will say your document is invalid.
Where is the document?
Your page 93. Is agricultural land, my lord. Agricultural land. So therefore, my lord, all these, there is no
Page number 93, Manas, whether the dealership has been given to them. Monday, the matter will be posted, Manas,
If this is, as a matter of fact, accepted in other cases, then a mortgage also would be liable to be accepted, would it not? What is the difference?
The dealership has been given to the person, then agricultural land for petitioner also it has to be given.
Therefore-
Is it everybody, whether an agricultural land dealership has been given?
If that is so, then give him one short opportunity to produce whatever you want. Yes.
I don't get that instruction, then the
Yes.
dealership has been given to them.
Learned counsel for the respondent seeks time to get instructions with regard to the documents produced as annexure H and whether dealership has been granted to an identically situated person as the appellant herein.
This is the dealership given.
Already, I've already produced for dealership.
Whether it is identical situation. Yes, list on Wednesday. Whether hearing is the difficulty. If they say the hearing, it may not, then it may not come on Wednesday. Yes. Yes. No further hearing, just list on Wednesday.
December 3, Sri Manuke.
I appear for the appellants, not in this matter. This is a batch of matters not challenging the enhancement and compensation. We have filed our paper books, my lord.
2012 notification.
Yes, but 2012 notification. Award, my lord, was for 15 lakhs, which has been enhanced to 54 lakhs. And my lord, in the second set of cases, 17 lakhs to 59 lakhs. On the basis simply of one notification, Lord, one notification of National Highway, where we were given 54 lakhs in terms of the guideline value of that particular area. There are, I understand, there are also two matters for enhancement. We've not been served. No?
So other connecting matters, my lordship, cross objection has been filed.
Can post all this together to a date.
Yes,
Because if there are other matters, then it should not be done piecemeal.
because no, there are some of them which are part of one order, which is copied in various other cases. Then another set note, which is again the same order with a small difference in values.
Claimant's appeal should-
No.
At least claimant's appeal should be connected.
Yes, yes.
Otherwise, if they-
Two of them are to the main matters. Two of them are connected, my lord. They are at serial number.
Yeah.
These are all the SLA. 3.16 and 3.17.
3.16 and 17 are the cross objection.
Claimant's appeal.
Responding to and three, my lord.
Who are 2 and 3?
We you take
Accept notice.
if they serve copies, they should serve copies on us. Have all
No. Okay, accepts notice for responding number 2 and 3. Accepting, delay will condone,
I'm sorry.
delay will condone.
Yes.
Right. By denying the interest if they succeeds,
My lord.
if they succeed in the appeal, we deny the
395.
interest.
Wait.
395 days.
39.
Accepted the cost of delay of 395 days in filing the payment for crop is controlled. On the condition that if the objector / claimant succeeds in the appeal, they will not, he will not be entitled for any interest of the same period.
16. I was required to comply with the office subjection. All the office subjections are complied.
Court fees,
Court fee paid.
court fee paid. Court fees.
Yes, paid. Therefore, the IA for extension can be
I for
dismissed as
instance,
withdrawn.
ಬರಲ್ಲ. Dismiss ಮಾಡ. All of these objections have been complied, including the payment of court fee. That I 123 will dismiss. This one report. Notice ಮಾಡಿ. Who appears to have responded.
I think, Lord, they'll take notice for the other respondents as well. Mr. Manu will take.
ಯಾರ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಹೇಳ್ತೀರಾ? ಯಾರ್ಯಾರಿಗೆ ಅಂತ ಹೇಳ್ಬೇಕು? ನಮ್ಮ ಫೈಲ್ ಅಲ್ಲಿ ಒಳಗಡೆ ಇರುತ್ತೆ ಬಂಡಲ್ದಲ್ಲಿ ನೀವು ಹೇಳ್ಬೇಕು.
3 roll. 1, 2 and 3 are board.
2 and 3
Housing board.
1,
Yes.
2, 3 came at least 5
4, 5, 6, 7 government.
5, 6 SCGP is requested.
Yes. 4, 5, 6, 7
Yes.
government.
ಕಾಪೀಸ್ ಕೊಡ್ಬೇಕು ಅವ್ರು. ಇಲ್ಲೇ ಇದೆಯಾ? ಕೊಡ್ಬೇಕು.
Kurusthal.
ನೀವು ಯಾವ ಕನೆಕ್ಟೆಡ್ ಇದೆ ಮನೀಶ್?
Uh,
3.1 ಇಂದ 3.10 ತನಕ
ಅಲ್ಲ ಬೇರೆ ಯಾವ್ದಾರು ಇದೆಯಾ? ಅಲ್ಲ ಬೇರೆ ಯಾವ್ದಾರು ಇದೆಯಾ? Other than this, is there anything else?
3.1 ದಿಂದ ಎಲ್ಲದರಲ್ಲಿ ಇದೆಯಾ? ಅವೆಲ್ಲ ಇಲ್ಲಿ ಅಪೀಲ್ಸ್ ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್.
Please. And please comply with the office objections if any in the cross
Let
objection.
them serve copies in all of those appeals, Lord, so that we have all of them with us
Correct.
when we.
ಮೇಡಮ್
There's only one reason for the urgency, Lord. Now, this is a housing board project and we have to allot sites. But we can't allot sites unless there's a final determination of compensation. And with this determination, Lord, which has already been done, the price has gone up from 1,500 rupees per square foot to 2,500 rupees per square foot for people who want to acquire sites in this layout. So if your Lordship can grant us a short date,
ಕೊಡಿ 2 weeks. 2 weeks.
so beggarly,
10th March.
10.
ನಂಬರ್
Wait.
ಕೊಡ್ಬೇಕು ಮೇಡಮ್ ನೀವು. ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಫೈಲ್ ಮಾಡಿದೀರಾ?
All paper books are filed, Lord, which are standard in all cases because they've simply applied some particular notification. Great.
Number 4, Shri B. Vachan.
Sir. Lords, I have sought for withdrawal of the writ appeals, my lord, with liberty to file a fresh writ appeal, my lords. There was a mistake from our end, my lords, we admit it. It is due to absolute inadvertence, my lord, there is no
RP
mala
was
prejudice.
dismissed on 15/6/22.
Yes, my lord. RP filed on, I'm sorry, my lord, I'll just state the dates, my lord. Appeal filed on 26/5/22, my lords. RP filed on 15/6/22, my lords. And my lords, it is in the RP, my lords, we have made a statement that we'll withdraw the writ appeal, my lords. Due to inadvertence, my lord, there's some confusion. We did not withdraw the writ appeal, my lords. Then the RP was dismissed on 21/9/22, my lords. On the same year, the order merges with the writ appeal, writ petition order, my lords. But however, my lord, since we have made a statement at the review petition that we'll withdraw the writ appeals, my lord, we are withdrawing, seeking liberty, my lords. The reason why we seek liberty, my lords, is this. It's a very small piece of land, my lords, the marginal land. The question is at what rate we have to allot it to them, my lords. The order passed with the learned single judges that give it at the guideline value rate, my lords. Our contention, my lord, is that we want to give it at the rate at which that said land was to be given to them on that day, my lord, the market value of the property. For us, we don't want it to be a precedent against us, my lords. The portion of the land might just be very small. There is also, my lord, instances where it is alleged that, my lord, we will give it to others also, my lords. If they are entitled to parity, they are entitled to parity, my lords.
But as a matter of principle, my lords, we can't give anything at guideline value, my lord. Because what we do, my lords, is in the very same layout, my lords, we also conduct auction of the sites. We also know what is the prevailing market rate, my lords. When we fix a rate for the marginal site, we fix rates at the rates at which we are selling, my lords, for the other plots. We can't give one person at a lesser rate and another person at a higher rate, my lords. We can't do that. Therefore, my lord, the principle of law is involved, my lords. That's the reason we are seeking liberty, my lords. Otherwise, the portion of land is very small, my lords.
It makes good.
I will permit to make family side of the
No, how much you are charging now?
My lords, we, as on that date, my lord, whatever is the prevailing market rate, my lords may kindly appreciate this.
Other than guidance value, what are your rates?
Whatever rates, my lord, prevailed as on that date, my lords, we would have known what is the rate by virtue of what auctioning that we are giving, my lords.
Auction may differ. Some may offer for 10 crore, one may offer for 10 lakh.
My lords, we auction, my lords, the corner sites as well as the intermediary sites, my lord.
This is a adjacent site.
This is a marginal land with an intermediary site, my lord. But we will know the valuation of an intermediary site.
According to what is the valuation? What is the difference you are claiming from?
Difference, my lord, one is guideline, my lord, I do not know the number.
So we
my
are,
lords.
we are only saying that if you know the numbers,
We can
then
make good
probably
offer.
it can,
We can ask
can
you.
just be settled here. That'd be the end of it.
submission. Your lordship will kindly see the impugned order. Impugned order itself makes it very, they have admitted, they will execute the sale deed in respect of 973 at the rate of, after accepting 3,58,000. That is the PDA has filed an affidavit that they will execute the sale.
No.
deed. And then for the marginal land of 33.75, they start the market value for that.
33.75 square feet or square meters.
Square,
One second, just a second. 33.75.
Square feet or square meters?
square meters, square meters,
Square feet or square meters?
square meters, my lords.
Square feet,
Square meter.
square meters.
Square meter.
Only to understand the
Square meter.
size.
33.75 square meter. They have admitted they will execute the sale deed for that also, provided I pay the market value. If the learned single judge has clearly mentioned, market value is based on the sub-registrar's guidance value is based on the market value from time to time. So, he has
No.
clearly stated
We don't-
market value you accepted it. There is absolutely no auction value at all here. He has not even thought for.
My lords, we don't
There
say,
cannot be any appeal at all.
my,
Whatever they have thought, it is in there.
Submitted that the authority has already allotted sites and petition and subject market value towards the market site. What is the market value? What is the guidance value?
there's a,
Market value according to BDA.
my lords, I'll place the numbers for your lordship's consideration. I'll place the numbers, it is definitely higher than the guidance value, my lords.
For that,
Because-
Market value, who has to decide? BDA decides is the market value?
We decide the market value, my lords.
no mind.
We,
Land,
yes, my lords.
on what basis?
My lords, we would have ourselves conducted auction of the property, my lords, which are lying in the very same layout, my lords.
Auction is the basis to determine the market value of the land.
My lords, may I submit this, my lords?
May-
May, I'll just come, I'll just,
Please.
973 is the medium price. 972 and 974, they have accepted for the marginal land at the rate of some 26,000 also. I am ready to pay that 26,000 for the acceptance. They have given, they have executed the sale deed in respect of 972 and 974. I am in between 970. I am ready to pay.
All you, question you,
Well, how
all-
can you say put-
don't harass like this, citizens.
I'll ask.
Review, appeal, again liberty, again another.
I'll
appeal.
For
verify.
last 14 years, I
May-
am taking again for.
Yeah,
May I submit this?
he has already legally allotted site holder. That is just a small extent he wanted it.
May I submit this, my lords?
Yeah, solve ಮಾಡಿ.
I'll,
President will write whatever you want, but give him. And
I'll
collect whatever lawfully is entitled, not the auction and.
I'll find out, my lords. I'll find out. I'll find out, my lords, and I'll place it for your lordship's consideration. My request, my lords, let the memo be on record so that, my lords, our conduct is not to be seen as bad. I'll find out, my lord, the actual numbers, what's the difference amount. I'll place it for your lordship's consideration.
The learned counsel for the appellant submits that the details of the market value of the property as on the relevant date will be made available at the next stage of hearing, list out. Please give a date.
I'll file it, my lords.
Yes,
Oblige, my lords.
give a date. please.
Next week, my lords.
17th. 17th. Solve ಮಾಡಿ
ಆಯ್ತು.
ಅದೇನೋ ಬರ್ದ್ಬಿಟ್ಟು ಹತ್ರ ಕುತ್ಕೊಂಡು ಮಾತಾಡಿ ಅಲ್ಟಿಮೇಟ್ಲಿ he wants land. ಒಂದ್ ನಿಮಿಷ ಸರ್, ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಕಡಿಮೆ ಇದ್ರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಹೇಳ್ಕೊಡ್ತಾರೆ. ಕರ್ಕೊಂಡ್ಬಿಟ್ಟು ಅಫಿಡೇವಿಟ್ ಎಲ್ಲ ಹಾಕ್ಬೋದು, another review for that, another writ appeal.
I'll find out, my lords. I'll place it for your lords.
3 square meters.
Oblige, my lords.
17th.
Number 5, the Ashok B. Patil.
So for the respondent,
Correct.
may I please, lords? For annexure W, page 121, was questioned in the writ petition. But the principal ground was, this is issued by the fourth respondent, Superintendent of Police of BMTF Police Station. And the principal ground was that as on that day, this BMTF lots was not in existence because the notification had expired by 2013. And that was subject matter of a few decisions of this honorable court. And what the in the decision which was relied upon by the petitioner before the learned single judge. In addition to the ground which was urged, what was noticed was in an earlier ruling, but this honorable court had taken the view that BMTF is not a police station to register any crime or to conduct investigation where any IPC allegation, offenses are alleged. But before annexure W, page 121 was issued, there was an earlier similar notice, which your lordships would be pleased to find at page 118, annexure U. And this is addressed to the appellant. Then the appellant replied, here you also will be pleased to see the property identified is number 70. And this is based on the complaint of one Mr. P.R. Ramesh, Secretary Karnataka Pradesh Congress Committee. And the appellant replied, annexure V, stating that property number 70 does not belong to her. And also she requested for a copy of the complaint of Mr. P.R. Ramesh, who is the fifth respondent before this honorable court in this writ appeal. He has been served and is unrepresented. The contents are more or less said they are issued under section 91 and 160 of CRPC. And of course, in both annexure U and annexure W, there is no reference to any crime number. Then this was the subject matter of the writ petition. But when the matter was heard before the learned single judge, annexure R1, page 146, the so-called complaint of Mr. P.R. Ramesh, a copy was made available. At page number 146 of the appeal papers. basically, what was, stated here is that earlier he had lodged a complaint to the commissioner, BBMP, with regard to certain encroachment of the government land or corporation land, and they have not taken any action. You'll also will be pleased to see the complaint to the commissioner of BBMP at page 149. Now, he does not identify in this complaint, he does not identify any property number. May I request your lordship to kindly see page 149 first, minutes, which was the so-called complaint by Mr. P.R. Ramesh to the BBMP commissioner. It reads, notes at page 149, dated 4/12/2014, regarding the encroachment of BBMP ward number 118. Regarding the above matter, there is a property of the corporation at the southeast corner of Lalbagh Road and Lalbagh Fort Road. It should be Fort Road. And this property was leased by the corporation long ago for setting up a petrol station. Now, few months ago, this petrol station was closed, and it was found that some vested interest had encroached on the western side of the said property and built a wall. Informing you that I have copies of the official documents confirming that the said property is the property of the corporation. I am giving you the said documents with this letter. I request you to check this immediately and clear the encroachment on the property of the corporation and preserve the property of the corporation as per the documents. Now, at page 150, your lordships find a sketch which does not appear to have been authenticated by any official department. Then, at page 151, some register showing the corporation properties.
Land leased for petrol pump
Yeah.
near Lalbagh.
And it is very mysterious.
Gate on Hosur Road.
Now, it's very mysterious that this complaint does not indicate any property number. It appears he was a formerly mayor of in the corporation, being a corporator also. And so this complaint was first given to the Commissioner BBMP. And his grievance before the BMTF, Commissioner has not taken any action, nor the BBMP officials have not taken any action. And in the complaint, principal complaint also, property number is not indicated. Based on this, two notices came to be issued to the appellant. And when I requested for a copy of this complaint, it was initially not given, but only given when the matter was being heard before the learned single judge.
In page 154, 2354 is the plot.
Page number 154, your lordships are referring. Lord, this is the master plan. This is the master plan.
2354 is the plot.
2354 is the property card. That property card, in fact, I have the original of the property card in the name of the husband of the appellant. In fact, slightly going back lots on the subject matter, way back in the year 1961, the father-in-law of the appellant had leased this property to the SO Petroleum Company, and it was on a lease basis. And a suit was filed against the petroleum company for eviction. After contest, my lords, that suit came to be decreed. I have produced the judgment and decree, At page 76, annexure J.
Only for the purpose of removal of encroachment.
Absolutely, absolutely.
Then they can do it. What are the main care?
Because annexure J, page 76, is the suit filed by the appellant and her children after the demise of her husband against Hindustan Petroleum Corporation. There the suit was decreed. Page 92, lords. I'm sorry, but it's a handwritten decree, but it's readable. Subject matter of the lease, where, my lord, there was a decree passed for eviction at page number 92. All that piece and parcel of premises at the foot of page 92, lordships find the schedule. All that piece and parcel of premises bearing number 1, Lalbagh Road, Mavalli, Bangalore City, consisting of 3 pieces of land measuring 5040 square feet and bounded on east by Lalbagh Road, then west by private property, north by private property, south by Lalbagh East Road. But this, as against this judgment, the petroleum company filed a regular first appeal before this honorable court. The lordships find the judgment of this honorable court in regular first appeal at annexure K, page 95. There were some arrears of rent and all, notes. The matter was resolved and the petroleum company is out of the property in pursuance of these judgments. And notes, in fact, the appellant and her children had entered into an agreement to sell the property in favor of a person. But my only apprehension is that this person is responsible for whatever triggering the action lots through the mayor, who does not give any particulars. Now the BBMP is also before this honorable court. It is for the BBMP to explain which is the corporation property, wherein lots this complaint of the former mayor. Instead, the notice are sent under the CRPC to the appellant. Even before the learned single judge or before this honorable court, BBMP has not made any statement with regard to the credibility of this complaint. Because initially the complaint was given to the commissioner, BBMP.
Soul number is 1. Soul number 1 according to the BBMP is that property. When it's showing to the suit, number 1 is
We'll have to.
With regard to the
Would agree with us that you will have to produce your documents before the authorities to find out whether it is their property or your property. You have all the documents according to you.
But BMTF has no jurisdiction to decide the title or possession. Now the allegation, the notice which is sent to us is based on the complaint of so and so, what your lordships have seen. That complaint does not disclose any of the numbers, properties, which are I mean, belonging to me, I have got the khatas also.
We know where the property is. The disputed property, everybody now knows. You say you have title. Produce the title that will end the.
The
issue
submission is only this.
Once and for all. Yes.
The jurisdiction of the BMTF
Hmm.
to issue notice under the CRPC,
Hmm.
as long as, my lords, it is not identified as a police station as held by this honorable court in many rulings.
Hmm.
I'm only questioning the jurisdiction of the BMTF based on this complaint where I am not named. They want to investigate into my title and possession based on the investigation. Now the BBMP has to answer because first the complaint was given to the BBMP commissioner. And my lords, they have to, I mean, show that yes, this is the property of the corporation, which the other side is wrongly claiming. The ball is in the court of the BBMP.
Hmm. Hmm.
Even, my lords, which the decision which I relied upon before the learned single judge, it talks about two questions. Whether it is a police station or not, or whether it is in existence or not, based on the earlier rulings. Invoking the provisions of the Criminal Procedure Code,
Hmm.
that's without jurisdiction is the question, where, my lord, this honorable court has taken the view all the khatas, my lords, even in 2015, in respect of the properties, including the one where the earlier, my lords, the petrol pump was in existence as a lessee under the father-in-law of the appellant. They all stand in my name. It is for them to, I mean, identify the property regarding which they want to do any investigation.
Dispute with regard to the title also. Title also, there is some kind of dispute. Yes. Yes. BBMP.
It's not as if BBMP has not initiated any action.
Hmm.
09.
Hmm.
There we have mentioned the property numbers also.
Hmm.
But in the unauthorized construction being made on the property.
Hmm.
The property is mentioned, the notice is number property number 1, 2, 2/1. Very same schedule is there.
What happened to this proceedings? What happens to this proceedings? 308 proceedings.
There she gave a reply, my appellant gave a reply to the BBMP.
Hmm.
They're denying and she asked for time to produce documents before the BBMP. For that, my lord, we have issued another reply at page 114. Regarding the encroachment made by the appellant on the public property and the footpath, my lord. Afterwards, my lord, a complaint was given to the BMTF by the respondent number 5. And BMTF has issued notices to both the appellant and also the BBMP, my lord, to produce documents. At that stage, my lord, she filed the writ petition. There was an interim order operating.
The document of the property in which the proposal is constructed in which the BBMP. Not to do with document anywhere.
And regarding the jurisdiction of the BMTF, my lord, it was not at all raised before the learned single judge in the writ petition. At the time of arguments, it was raised that relying on the earlier decisions, my lord, the term of the BMTF had expired. Now the government orders have been produced to show that BMTF has been, term of the BMTF is being extended from time to time. Till December 31st, 2024, it was extended. Now the latest, it has, whether it has been extended or not.
Even as on the date of issuing the notice, it was,
Was
jurisdiction was there.
Even in the writ petition also, she has not produced any document except producing the Kata certificate and the judgment of the.
Yes,
With-
that's
No other title deed have been produced. Kata certificate is not a title deed.
So the BBMP has to produce the documents according to which.
And the action of
property
the
in question.
BMTF is questioned in the writ petition, not the action of the corporation. That is why, my lord, writ petition after considering, learned single judge after considering these contentions, my lord, has directed the appellant to
Yes, what do you say?
FI for the state. But in fact, in 96, there were proceedings which created the BMTF.
Hmm.
And I'll just forward the copies of the proceedings. This is as per the government date, notification dated 19/3/96.
Hmm.
If I'm permitted to read, my lord, the last portion, the function and functions of the task force shall be as follows, namely, better protection of the property belonging to the government, the Bangalore City Corporation, the Bangalore Development Authority, the Bangalore Water Supplies and Sewerage Board, the City Municipal Councils, and the Slum Clearance Boards in Bangalore. Sorry, my lord, this is not very legible. But at the next page, my lord, one of the functions is the detection of commission of any design or committing any offense, of investigation and prosecution of such offense relating to the unauthorized occupation of any land which is in an area under the following enactments. And then it enumerates, my lord, the Karnataka Municipal Corporations Act, BDA Act, Municipalities Act, Water Supply and Sewerage Act, and Slum Areas Act. My lord, now this property admittedly falls under the BBMP, my lord.
The difficulty is this.
Please, ma'am.
When there is a dispute raised as regards the ownership of the property, can this task force take action to decide the question of title?
My lord, as a matter of fact, I would put it this way, my lord, there is no action taken. My lord. There is a complaint received. It's,
There appears to be a demolition.
my lord, that demolition was not carried out by the task force. There's a complaint received and
They did illegally demolish. Then only, my lords, I complained that you cannot do it.
Anyway,
my lord.
so no.
On,
Question is this, what is the power?
please, on basis of that complaint, my lord, we have issued a notice for them to produce the documents. My lord, now our job will be to check the documents.
If it is found to be not genuine, then we forward it to the authorities to take action in accordance with law.
Therefore, the question is
Please.
this, can you call for the documents? They have all the power to call for the documents and to decide whether it is their property or not.
The
No.
BMTF police station.
My lord,
yes.
it is, High Court has held that it is not a police station, my lord, but that, my lord said last time
Can you
indicated
call for
that.
the documents would be the question.
I think
Legal
Justice
question.
Keshav Narayan did. Justice Keshav Narayan did.
Please.
In fact, my lords, with the ruling which I relied upon.
But, my lord, in fact, there's one more judgment, my lord, the single judge, it might be of persuasive value. I'll produce that on the next occasion, my lord, which says that any offense which is committed under the Municipalities or the Municipal Corporation Act can be looked into by the
To
BMT.
be an offense.
Please, my lord. Now, encroachment is an offense.
Question is whether it is encroachment is into BBMP property or not.
My lord, that too,
There
right?
appears to be some bona fide dispute with regard to the nature of the property, where the property is, and whether it is BBMP property.
My lord,
It appears they are contending, we don't know on the
Please,
facts of the
please.
case. They are contending that there was a petrol pump there and they were being paid lease in respect to the petrol pump. It is only in that property that they have made construction. That appears to be their contention.
very
If
well.
that is so, if as a matter of fact, there is a property, they say this, the notice they have been given is in respect of property number 70. You say, we have nothing to do with property number 70. We don't want 70. It is
Good.
not nowhere near our property. That is the reply.
Reply, yes.
My lord, in fact,
And in the complaint of Mr.
70
P.R.
is the
Ramesh,
old number. The new number is 1, 2 and 2/1.
no material for
That is what the notice indicates.
Please see the notice that has been
Please.
given to them.
first time.
Annexure U and W.
It says,
My lord, ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪಾಲಿಕೆ ಸ್ವತ್ತಿನ ಸಂಖ್ಯೆ 70.
hmm,
It says number 70. Annexure W clarifies that point. my lord. ಪಾಲಿಕೆ ಸ್ವತ್ತಿನ ಹೊಸ ಸಂಖ್ಯೆ 70, ಹಳೆ ಸಂಖ್ಯೆ 1, 2 and 2/1. The new number is 70. The old numbers were 1, 2 and 2/1.
1, 2 and 2/1, they produce Khata certificate given by
Lord,
the BBMP.
All we are asking is to treat it as a notice, show the documents. And if they're genuine, then there's,
Please tell us what is your jurisdiction for that purpose.
my lord, that is, we derive our jurisdiction from this government notification.
Exercising power of investigation under section 91 and 160 of the CRPC.
Please.
Unless claim is registered, can you issue notice? And unless you are a police station, can you put the application? They can do it. 380 is all right. They can.
My lord, here, my lord, in this notification, my lord, in this notification, my lord, the third paragraph says, may I read, my lord, the preamble, the third paragraph, my lord, unnumbered para. In order to enforce these provisions effectively, it has been decided to establish a task force for prevention, detection, and investigation of offences and prosecution of persons indulging in an unauthorized occupation in Bangalore metropolitan area. It is proposed to post the police officers from the police department on deputation and declare the force as a police station to enable them to register and investigate cases. Hence the following order, and then the order follows.
FIR should be there. If it is a police station, then notice.
My lord, initially it is just a complaint. We'll investigate and then we'll file an FIR. That is,
For restricting FIR, you are summoning the witness.
Lord, summoning is one way of saying it, but if they produce the documents, let them not be physically present also, my lord. All we are requesting is to produce the documents and.
Which is the document says that police.
Yeah, lots of, which I relied upon before the learned single judge is a WP number 32255 and 61/2013 decided on 29/1/2020. Two questions plots were considered here with regard to the existence. That expiry was at page number 4, plots. There the crime was registered. And it was challenged on the ground that it was registered after the expiry of the BMTF. Then, my lords, in para page number 4. in para 5, my lords, at page number 6. An earlier decision of this honorable court in criminal petition number 6604 of 13 was noticed. And there, my lords, on page number 7,
It's taken, it goes against him, but it's a police station.
section 2, yes, is also noticed. And the earliest ruling was of lords of a learned single judge of this honorable court.
Go through this, Mr. Sudev, this judgment, ನೋಡಿದ್ರಾ? ನೋಡಿ ಮತ್ತೆ.
Even to understand,
There are series of rulings.
there is another order by this honorable court itself in the year 2024. My lordship permits me some time. I'll verify, my lord, and make submission. Short accommodation maybe.
Yes.
And I'm told, my lord, this question is pending before the Honorable Supreme Court with regard to the powers of the BMTF. That's what is the statement made, my lords, in one of the rulings.
May I request, my lord, that I'm also not aware of that. In fact, I'm
Lordship Justice Keshav Narayan has held first time, if I'm not wrong.
in
We will
2013.
It is not a police station and they cannot register a fire. Later, one of the judgment and that if this is taken, then it is a, they have registered, but time was expired in the case.
But here, my lords, in ILR 2018, His Lordship Justice B. A. Patil's ruling, my lords, exhaustively the case law was considered and held that it is not a police station and therefore they cannot exercise police powers.
My lord, I'll verify that also.
Yes, please.
I will supply a copy of that.
Not stop criminal action. You have your own beat.
Lord, now.
That complaint is so bald, BBP has to identify. It appears it's a political expediency, my lords.
AGA seeks a short accommodation. Wow. Yes. When do you want it listed?
My lord, anytime, my lord's find it convenient.
After, week after.
Please.
19th March,
Great.
December 6. Mahadevi remand.
What is the situation?
Lords, in this, the petitioner. He participated in this way vacancy because in the earlier round he didn't get because of his rank. He participated in the in this round and his first choice was dermatology in AJ and Institute of Medical Sciences. Lords, his rank is 1,26,227. Whereas my lords, in the state vacancy round, he is not allotted that seat, though his rank is also good, better than the candidate who has been allotted in the rank is 148,431.
That person has made a party?
We do not have, if I request my learned friend to give the details of the candidate, except the rank number we do not have.
Memo,
how
these things have happened. Subject to, my lord, further I have the documents also. Well, the petitioner with NEET ranking 126227 for the first time registered on 16/18/1/2025 entered options to participate in the counseling in the mop-up round. First time he entered is for the mop-up round. He had entered as many as 12 options in which he had not opted the subject MD dermatology in the AJ Institute of Medical Science. Owing to his rank and priority options entered, he was not allotted any seat in the mop-up round. Perhaps, my lord, if he has made this AJ Institute, he would have got it. Had the petitioner, I have written so, had the petitioner entered this college as one of his priority options, there was all the chance of getting his seat, this seat. Then one Aditya ji, who is rank number 130977, who also participated in the mop-up round, had entered as many as 188 options. In the counseling, he was allotted the seat MD Dermatology in AJ Institute of Medical Science, which was his 144th priority options, and had paid the fee, downloaded the admission order, but not confirmed the joining of the college. Then in the stay vacancy round, pursuant to the order passed by Lordship in 2828, or 2848, I'm sorry, 48 of 25. Students who have participated in the mop-up round and obtained the seat were permitted to enter options. The seat which they were holding was also included in the list of virtual vacancy seats published by the KEA. But they were holding the seat, my lord, but we have said, I have the notification here. We have said that that will also be considered. So we will advise the students to enter options for that also. During the stay vacancy round, the petitioner entered only 2 colleges as his options. When the petitioner was counseled,
Was not one of his options.
this is one of the options. But his ranking comes earlier. So when the petitioner was counseled, the seat held by Aditya ji was not released by him because he was still holding the seat. His turn has not come.
Just a moment.
Once again, his turn had not come. Petitioner was counseled and the seat was not available. So this was not allotted to him. Aditya ji, when appeared for counseling, he went for an upgradation. He released the seat held by him and opted to join MRMC Gulbarga, which was his 17th priority option due to stay vacancy in the stay vacancy round. The seat released by him was opted by the next available candidate is 14843 on Dr. Gauri. It is these circumstances where petitioner did not get it. In the iteration, this thing itself is there. Brochure is very clear. Sir, iteration, as per the ranking, it will be called. So iteration will not go back. It will go further. This is in the choice 1, choice 2 is like that only, my
Lord, I flagged it cross. I flagged it cross. Cross flag. In the process.
Allotment logic, down below it is.
May I just point out? Sir, brochure is. I may be just permitted to point out that.
Allotment logic.
If KE had paginated it, it would have been convenient for everybody.
I'm
Yes,
sorry,
at least next year, please page it.
Yes.
They may need a judicial order now.
A mandamus for paginate may be required.
ಇದಾಗಿದೆ. Seat allotment logic. ಇದೆ.
Beginning itself says that it's as per ranking. The counseling will happen as per ranking.
It says very clearly, may I submit?
Just a moment. Online allotment will be based on merit, priority of options entered by candidates and roster prescribed by the government. Eligibility to participate in each round is subject to conditions. Based on seat matrix issued by government, action will be taken to allot the seats to candidates based on the eligibility and reservation criteria. Options entered by the candidates will be considered for allotment based on the merit. While allotting seats to candidates, computer will check the availability of seats for each option based on priority of options. Order of allotment reservation for each category is detailed below for the information. The allotment of seat for a particular candidate is based on his or her rank and priority option entered. In any category, candidate option is searched in general category and allotted. If no seat is available in general merit, computer searches the Hyderabad Karnataka general merit and allot seat. Seat is not available either in GM or GMH, then it follows the priority order as shown above. This improves the category of seat allotted to roster. In the same manner, all the categories improved as per.
This is how, my lord, they.
Yes.
In this case, my lord, it is so fortuitous. Because, my lord, they were allowed for upgradation. My lord, by virtue of the order, my lord, they were allowed for upgradation. He has already joined the college. He has paid the fee, full fee, to join the college. Wherever they have paid the fee and joined the college, my lord, they are still holding that seat. But, my lord, to be on the safer side, my lord, to suppose he may leave. So we have made a virtual list of candidates where they were holding this seat. We advise the students who are coming for counseling, these virtual seats also you can enter options. Only that will be released only when he releases it. In this case, he has gone for upgradation. The person who, that upgradation happened.
Upgradation happens after the.
That is the only explanation which I can.
This is what is the violation of the order of the honorable court. The sway vacancy round was fresh round for all the candidates as per your lordship's order. I read out the portion because it is not there in 2848, but the lords have passed in 4065 of 2025, wherein my lords have said the KEA will notify the last date for surrender of seats already allotted in the mop-up round. So as to make the students eligible to participate in the sway vacancy round, and the last date of surrendering seats already opted in the sway vacancy round in the website of KEA. What they have done in this case is, my lords, this is nothing but cheating on the candidates. These the KEA withheld 257 seats. That's what yesterday I was making submission. This is going to mark so many students. 257 seats.
Those seats were not
surrendered.
Not
this order,
not specifically surrendered.
They have not surrendered, my lords. Please.
They held on.
They held on, and they were allowed to pay the fee, and they withheld and they participated. It is against your lordship's order. And KEA did not even disclose till my lords have we filed another case. Then in the night, the virtual vacancy round was released. Virtual vacancy round itself is violation of the straight vacancy round, because there is no virtual round at all in KEA so far. Even when we asked my lords before this honorable court earlier, they said we will follow next year. Because when we pointed out before this honorable court.
Your contention is that there was no cutoff date for the giving up of the seats and participating in this.
They had actually on 14/2, the KEA said surrender all seats and then participate. They should have done it very fairly. They have done it on 14/2. Second was on 21, which is a misleading notification by them. My lords, I have given in my petition only, this itself caused all this havoc of 257 seats. Kindly, my lords, page number 11, annexure A itself. C clause C. As per the orders of the Honorable High Court in 2848/2025, candidates who have been allotted in mop-up round can participate in sway round. This blanket order created a lot of problems. On 21, this was done. Based on this, what has happened, my lords? Students did not, 257 students. Our petitioners have promptly, they went and surrendered and they have taken allotment in the previous petition, my lords. Whereas in this, because of this, 257 candidates did not surrender their seats, which is
They have
straight up
already joined.
in violation of this honorable court's order. And what they did, now, what happens, my lords, there will be two, according to the, now, what the government has submitted. There are two types of allotment in Sri now. One is those who all participated afresh, because it is a fresh round. Fresh entries have to be made according to their own condition, according to honorable court's condition. All of them have entered the fresh rounds. This petitioner also entered fresh rounds. He gave, according to his ranking, gave AGI as first statement. Now what happens, my lords, in the order of merit, even the seat logic, allotment logic also says, as per the ranking is merit. Now, when the state agency of they have allowed all the candidates to make fresh entries, I should be getting it. How can they make, how, my lords, please, how can they mop-up round up? How are they taking mop-up round here when the mop-up round is already closed and your lordships ordered for a surrender of seats? That's the reason, my lords. Yesterday I was very specific, my lords. Your lordships ought to have directed 257 seats. They were withholding. It is straight away in blatant violation of the court's order. Now they say, because of the seat allotment clauses of the software. So those who are holding only, this is allotment within the 257 candidates, not about the ranking. Within 257, they have allotted now. One is holding, the other one is who is already there. So they made 2 rounds in stay vacancy round. Yes, who is it permissible now? That's what I'm requesting this.
Yes, please.
Surrendering of the seat was not appropriate for our and the petitioner, they did not join the college. Petitioner holding a seat, petitioner also holding a seat. They did not join the college. When we spent around the pop-up of those students were there, already joined the college. What do you want to say? Similar students?
Yes.
In the pop-up.
Let them place it on record.
I'm a learner friend saying, there is no, she's arguing contrary to what she has contended in another petition. In another petition, they unison said that this stay vacancy has to be published. I have the order copy. In another matter, that is where Pramodini Krishna appears. So we have virtual, the seats were now published. Now she can't say it can't be, there is no provision to publish the virtual list. It is at their instance. In any event, now there is a student who has already taken this seat. Let her make them a party. I will file a statement of objections. Then we'll argue the matter.
Kindly have it on Monday. We will file.
No, no, Monday I cannot.
It is a matter of merit, my lord.
Please.
My lord.
List on Wednesday.
Yes.
Notice, so-and-so takes notice, so-and-so takes notice. List on Wednesday. Place the,
My lords, let them produce today itself, my lords. We will make the party also, the others. My lords, may I submit, my lords? I am not going against any of this. They are, let them prove, my lords, in stay vacancy round, they can allot the seats on the basis of virtual round. Kindly see, my lords, this is in fact, it is going against.
details are there? Details are there? Yes. Please make it available. Yes. Wednesday.
Hearing on IA,
Wednesday.
5th March. Hearing on IA, number 7, Sri Chetan B.
1247.
Compensation in this, we have filed an impleading.
Note is not yet ordered.
Impleading application for R2 and R3 were necessary parties in this matter, you know, by oversight this. And similar matter, this honorable court has allowed the impleading application MFA 10456 and 457.
They are not parties before the reference court.
They were not party, but however, the similar matter for the quantum, this court has allowed the impleading application. They are the beneficiary. They are
Compensation than the real lives.
R3 are the beneficiary of this.
issue notice on.
Prashant, we are for R3 limit.
Respondent. Yeah. Yes. We are Prashant. Pending counsel accepts notice on IA 1 of 25, IA 1 of 18 and on main. Attention, sir, copies of the papers in the respective form.
Number 8, Sri Paniraj Kashyap.
My lord, son. My lord, this is a case where award is been passed against a dead person.
SLO.
No, my lords, by the trial court,
Transport.
reference court, my lord, son. During the pendency of the case, my lord, son, the claimant expired. And LRs were not brought on record.
My lord, they should go before the, the appeal had, the award and the proceedings had abated against the, but they should have filed application to set aside abatement, my lord. Now they directly filed appeal before this honorable court, my lord. It's not maintainable, my lord. My lord,
There you have to be corrected.
My lord.
There you have to go, no?
My lords, the award has been passed, my lords, and award has been challenged by the legal heirs before this honorable court. My lords, I may be given liberty to approach the trial court.
Always there, you withdraw. Go there, revive, fight that on merit and then come back.
My lords.
To take the leave of the court, you withdraw this with the.
My lords, I will file a necessary memo, my lords. ಇವಾಗ ಹಾಕ್ತೀನಿ.
Number 9, government advocate.
That's okay.
ಇನ್ನೊಂದು ಕೊಡಿ.
For the CH-3, yeah.
Please.
Nothing,
What remains in this?
nothing remains.
Nothing remains, no?
Nothing remains, even the writ appeal can be disposed of. The only point is that RSA. If they succeed in the RSA, everything will come. Therefore, the writ appeal also can be disposed.
It'll be closed.
Please.
Yes.
They will not give anything to you. There is a RSA order.
RSA, there is no order. There is an, in an appeal, there is a declaration which has been given in favor of the respondents, challenging that they filed the RSA. There is no interim order or something like that.
It's pending, madam.
Relations with competence of the court only when the person entering the name of the government. His appeal is preferred by the state and its function is challenging the order of the learning civil. Page 31, in W number 3990/2015. Considering the contentions advanced on both sides, the petition filed by the first respondent hearing was allowed. And the impugned endorsement dated 28/6/2007 of the second respondent deputy commissioner was quashed and set aside. The fourth respondent Tahsildar was directed to enter the names of the petitioners in respect of the land of question, subject to the result of the RSA, which was pending between the parties. It is submitted that though no steps had been taken pursuant to the judgment, a memo has now been placed on record on 28/2/2025, which shows that the entries have been made as directed by the learned syndicate. In the above view of the matter, nothing survives for consideration in the appeal. The appeal is closed. However, we make it clear that the entry of the petitioner's name in the RPC will confer no benefit on them in the pending RSA, and that the RSA will be considered in accordance with law and decided appropriately. Or pending application.
Number 10, Sri Nagaya.
My lord, appear for respondent in this case, a respondent Bhavan. A week time may be granted, my lord. Due to personal inconvenience, senior is not appearing.
But the matter may be taken up after 15th of March.
Yes.
Please,
Obliged.
please, folks, obliged.
For further hearing. Number 11, Sri Prithvi Shamke.
We'll just come back after the list.
Number 12, Sri K.S. Naresh Santosh. Government advocate.
Appearing for petitioner in this matter, my lord.
Yes.
Lord, it is a writ of mandamus. The petitioner has applied for the PG seat. The seat was reserved for SC category, my lord. Without further taking the seat to the second round, it is allotted to the general category. There was an intimation issued by the National Commission.
This again is a case of decategorization.
Decategorized.
So no student was available. Thereafter, my lord, it was. Then the percentile was reduced.
Numbers are there.
Yes.
How many were the?
I have given a statement of the file.
Statement.
Actually, you can know only.
Please, Lord.
Statement is filed. Yes.
When he become eligible.
After the percentile was reduced. Date, no, yes, I have given the date. Petition was registered on 27/11/24, my lord.
All dates were
12/11/24 was reduced.
Yes, what do you say?
Lord, the petitioner was eligible as on date of the issuance of the notification by the central government. Lord, not keep kindly see annex.
What is your percentile? How were you eligible then?
My lord, my percentage was reduced by way of a notification, my lord, which is produced as annexure F, my lord. 12/11/2024, my lord.
12/11?
12/11/20. Ayush, my lord.
Ayush.
I see.
12/11. Okay.
Yes.
Please, ma'am.
Thereafter, petitioner registered on 27/11.
27.
Yes.
Decategorization.
Decategorization, my lord, on the mop-up round itself, second round itself. Second round was between 16 and 19. Final results were on 20th. In the second round itself, the seat was offered for SC students. As there were no students from SC category, the unfilled reserved seat was decategorized and was offered to the eligible candidates. As said, my lord, in the para 2 of the page 2, my lord, page 2.
Final results of second round was published on 2011. Second round SC reserve seat was first offered for SC students. As there were no students from SC category, unfilled reserve seat was decategorized, was offered to eligible candidates on merit in the very first round, in the very round, as contemplated in section 9. She is registered only on 27/11/24, eligible to appear in mop-up round. Option entry for mop-up round was 27-11, 29-70. Categories of second round since it was not. Total number of only 8 PG seats in Unani.
No seats were
All
available.
seats-
They're not
All
shown in
the
seat
seats were
matrix.
allotted in first and
Yes.
second round itself. Hence
Only
there
one
was no
seat allotted.
For allotment in the mop-up round. Able to get it. Yes.
Please.
That is all there is. Yes. Petitioners file seeking the following reliefs. It is contended by the learned counsel for the petition that the petitioner had acquired eligibility to participate in the PG Ayush 2024 selection by the lowering of the cutoff percentile by annexure
6 page 26.
by annexure M communication dated 12/11 F communication dated 12/11/2024. It submitted that pursuant to the reduction of the eligibility percentile, the petitioner had made, petitioner who is an SC candidate.
SC can.
Had registered for the allotment on, she does not say.
On 27/11.
No,
Registered.
that she does not say, had registered for allotment. It is submitted that she had submitted a representation dated 26/11/2024 before the respondents
Yes.
seeking the continuance of the reservation in favor of SC and ST candidates, so that she would be entitled to participate in the selection as an SC candidate. Full stop. It is submitted that the KEA had decategorized the available reserved seat for SC, ST candidates and had conducted the selection, treating those seats as open merit seats, and the petitioner's chance to get a seat for get a PG seat was therefore defeated. On these grounds, he has approached this court. The second respondent had filed a statement of objections wherein it is stated that the petitioner had become eligible to apply for the PG course only after the NCISM had reduced the qualifying percentile by 15% by its notification dated 12/11/2024. It is submitted that the first round of counseling option entry was held between 6/11 and 8/11/2024, and the final results were announced on 12/11/2024. It is submitted that in the first round seat matrix, there was only one seat in Unani reserved under the SC category in the Government Unani Medical College, Bengaluru. As no student belonging to SC category claimed the seat, the same was carried forward to the second round of counseling. Option entry for the second round was held between 16/11 and 19/11/2024, and final results were published on 20/11/24. In the second round of counseling, the SC reserved seat was first offered for SC students. As there were no students from the SC category, the unfilled reserved seat was decategorized and offered for eligible candidates on merit in the second round itself, as contemplated in Section 9 of the Karnataka Selection of Candidates for Admission to Government Seats in Professional Education Institutions, bracket Regulations of Admission and Determination of Fee, bracket closed, Act 2006. It is submitted that the petitioner had registered for the selection only on 27/11/2024, and she was eligible to appear only in the mop-up round of counseling, since the PG seat in Unani already stood decategorized and offered in the second round of counseling itself to general merit candidates. There was no seat available in PG Unani in the mop-up round. Full stop. It is submitted that there are only 8 PG seats in Unani medicine, and all the 8 seats had already been allotted in the first and second round itself, and there were no seats remaining for allotment in the mop-up round, and the petitioner was therefore not able to get a seat. Full stop. Having considered the contentions advanced on either side, we notice that the petitioner's eligibility to participate in the selection occurred only on account of annexure F, and that she had registered for the allotment only in the mop-up round. Full stop. By the time the petitioner registered for allotment, the seat in PG Unani had already been decategorized and offered to general merit candidates in the second round itself, and the seat stood filled up. In the above factual situation, we are of the opinion that the prayers as sought for in the petition cannot be granted. But petition fails, same is accordingly dismissed.
Right, I'm sorry to interrupt in between minutes. In serial number 10, there was an interim order which has to be extended. Please, minutes.
Number 13, for orders. The MR Hirematad.
Yes, here for the appellant in the second one, my lord, 733 of 2011.
In RFA 1094 of 2011, done. Yes, sir.
RFA 733 of 2011. Lord, I will take steps in respect of R3, my lord, R6B. So far as the R6C is concerned, the notice went, my lord, it has been refused. Notice may be held sufficient.
R6?
R6C.
In case
None case.
Again, madam.
733.
R6C is concerned.
R63.
Yes,
R6C.
6C. Notice refused.
Refused.
May be held sufficient.
Yes.
Lord,
R6C.
C.
Postal error.
Lord,
The reasons.
R6B is the
R6C.
one submission.
A and B
R6B is concerned. I may be given 1 week's time. I will ascertain the character.
It is time to
Let's go for a third.
R6B, alva?
B. 1 week, Lord. Okay.
To take.
The third one, third item, non-compliance of office objection on IA 1 of 25. For CI, schedule not mentioned in the application is not forthcoming in the decree in OS number. Lord, in the decree it is not mentioned. It is in the decree it is not mentioned, but in the plight it is mentioned. There is a decree in my favor, my lord, in respect of the application schedule properties. My lord, granting half share. Now, my lord, contesting respondents are putting up the construction. Therefore, my lord, I have sought for injunction restraining them from putting up construction. Lord, it is half share is there in my favor. Let them not put up construction, my lord, during the pendency of the appeal. They shall not alter the structure, the nature of the property. Lord, I saw the copy and the other side is represented.
He's saying something, not paper book. He's saying that you are putting up construction. He wants you to stop that.
He cannot put up construction, my lord. How the copy, my lord.
ಯಾರ ಹೊಲಿ ಕಳಿಸಿದ್ದಾರೆ ನೋಡಿ unconsent for the applicant submits that submits that in a decree in OS 118 of 2007. There is no mention with regard to the schedule. However, in application, he has mentioned the schedule as per the claim. Below the said submission, office objection on IA 1 of 25 is overruled. At the request of learned counsel for the respondent, list next week.
Yes, we-
What do you
and
think?
Monday or Tuesday, orders will not on 12th, you are not.
12th ಮೇಲೆನೆ ಬರೋದು.
Second by 17th.
17th.
17th, please. Earlier than otherwise they put up construction. Monday or Tuesday we got that, 3 days. Or 12th.
Dispendence ಇರುತ್ತೆ. ಏನು? ಕೇಳ್ಕೊಂಬನ್ನಿ ನೋಡಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ.
Construction put up when the appeal is pending will not inure to their benefit anyway. If ultimately the appeal is allowed and you are found to be entitled. Yes. 17th.
17th. Madam, you have to file objection, otherwise on that day application will come.
Number 14, Srimati Vaishali Hegde.
Falls within a very small complex lordship. Petitioner, the tenants of your lordship for they were regularized in effect from 1998.
Regularization date of effect. Not today, please. We can't consider it today.
Very well. The lordship,
Can be on a near date.
19th March.
Yes.
December 15, Srimati MP Geeta Devi.
Takes time. Takes time. Takes steps.
December 16, Srimati Anuparna Bodolai.
Maintainability.
Next matter.
Below 10 lakhs. 2256, MFA 2256, how is it maintainable here?
No instruction.
Any day, next week.
Not delay schedule. PSI ಕೊಡ್ತಾ ಇಲ್ಲ. 16.
16.1.
16.1.
2256 September.
District Court. This will change appeal. To where to file appeal, you have to ask client that.
Client tells you.
If this submission you are making, we are going to dismiss. And you are not aware about the procedure.
The client will tell you where to file.
Very simple. Senior civil judge has as a reference for pass the order. Value is below 10 lakh. File a memo, take back this and present before the appropriate court.
Maybe pass on.
Don't ask client.
Ask his email. What about 17?
December
17
17,
is Kanwa.
Government Advocate.
Yesterday's.
Kanwa.
This is Kanwa, no?
What is state has filed this appeal?
Oh. Competitive authority has filed the appeal.
KPID matter.
Okay, yeah.
Ah.
At the request. Weeks time
EF
to file.
cover acknowledgement.
2 weeks.
Notice to R1. Kanwa server the. Please, you have taken notice.
No, my lord.
Does the state
Where I-
take notice for R1? Because it is under an administrator.
Yes, ma'am. And state I
Correct.
can't.
Correct. So for respondent one is notice is not, service is not complete is the objection.
Lord, in fact, the matter belongs to KPID. Matter.
Correct.
Mr. Veeresh Budiyal appears, my lord, we are not aware as.
Not the question. This society is Kanwa Sauharda Credit Company. That cooperative society is under administration by you now, by the state. There is an officer appointed.
My lord, that is where, my lord, we kindly have it next week, my lord, we'll verify and we'll see whether.
Question is, who are 2 and 3?
Don't even have file. In fact, we don't even have the file, my lord, the file is with the same.
Oh, Nanjundaya is there. Nanjundaya is there, Canara Bank is also there. Hmm. Does anything survive? This matter?
We'll verify
Anything
it and
survive
take
in
a sub-
this matter?
This matter, we were not aware of this matter, my lord, this matter.
We'll
is
verify and
serious.
take a submission, my lord.
Because this is one,
They have
one
not
case
filed
where
wakalat.
it has been rejected.
They have not filed wakalat in this.
It is not filed.
Viraj.
Is that correct?
In fact, their name has to be shown.
Sir, my lord, we require 2 weeks time for them to comply with the office objections also, my lord.
So file wakalat.
No, we'll be doing it soon.
Is it rejected just only for our purpose notice, yes. And the companies, 12 cases.
But for respondent number 1, I think we can take, state can take notice.
State is appellate. First
It
restoration.
has to be changed.
Provisions filed in so and so support. Why is the same injunction? Then what happened? The petition for the dismissed consequently. The response began without going to objective banker has made out cause for, oh, that is where. It is already mortgage property.
Yes.
The property is mortgaged to the Canara Bank. They have first charge. Yes.
I think this matter is seized before the Honorable Apex Court. As to who has the first charge.
That is pending
He,
consideration.
Dinesh Udyar, SI now. Submits that he has instruction to appear for the appellant. And he will file wakalat in weeks time for the appellant and also take steps to the respondents.
Hmm.
18, Srimati Sumana Baliga.
Hmm. Hmm.
Fourth respondent, the student who will be getting affected before the student.
NDPDF treated Prakash Street as she is eligible as per Mapafrom criteria. Cancel allotment of postgraduate medical seat, NDPDF to SCGC wrongly allotted in violation. To grant such other leaves. Yes, what is your contention?
Here, what has happened is
Hmm.
petitioner is more meritorious than the fourth respondent lordship. And during the first round, she got the seat in ENT lordship. She wanted to upgrade it. She appeared for the second round. Second round, she got the seat lordship. But because
Which
of.
seat did you get?
She got the seat in
Sorry?
general surgery.
General surgery where?
Vide.
Then.
Even
Was
though-
it all India quota or
State.
state quota? Okay.
And even though she has received the seat lordship, KEA has given, after that, KEA gave the admission order, but college refused to admit her. Because there was some problem with the allotment of seats. Vaidehi Medical College had 18 seats, but 20 seats were allotted by the KEA. So the KEA requested the petitioner and other students to appear for the mop-up round. In the mop-up round, even though petitioner has opted for pediatrics, she was not allotted. And fourth respondent, less meritorious than the petitioner, was allotted with the seat lodge.
Why PDA, I have it.
Hmm.
Now the whole thing starts from the beginning. The seat bank itself, 22 by the government. You know, more number of seats from this time. But government is not a party, you know, because I still not want to get information, how is it work out? I cannot say that whatever they are doing, they are allotted. The two schools have to be displaced, then they reduced it. Two schools have to be displaced. That is not this, they were continued on the walk. And they'll got it, most of them got a seat.
What is the seat you have got now?
I have got it in general session. I want in pediatrics.
And the other student
Got
according,
it in the second round, and then he got in pediatrics in Arkash.
You want to swap, I have no objective. Something will do the food process. I will die, I think I will. They also have to admit a party. You're not a party in this case, but what limited instructions I have is that there was some communication from the NMC to reduce, and that has been communicated to the college, and the college has gone ahead and made these admissions. But I'll.
Vaidehi is not a party here?
My lords, I am appearing for respond number 2. Vaidehi, my lord.
Yes.
My lords,
What-
we have the KEA has wrongly allotted 20 seats, my lords, and we have communicated to the KEA saying that this was wrongly allotted. Our limit is only 18 seats. My lords, thereafter the KEA has written to us that you allot only these 8 students, my lords. They've given the list of students and said you allot only these 8 students for the second round, my lords. Thereafter, for the third round, they have again issued a letter, the communication by the KEA, saying that you allot these number of students. So from the college, there has been no violation. We have not admitted anyone outside what KEA has instructed us to allot. That is my stand.
Now, where are you allotted for general surgery? Akash. Vaidehi. And where are you allotted for pediatrics?
The respond number 3 call.
Akash.
You're appearing for it.
Akash. No, I'm appearing for Akash.
You're appearing for it.
No, he is appearing by himself.
He's appearing for it.
Akash institution.
You are appearing for Akash.
Akash institution.
How did that happen? Both of them participated in the mop-up round. So how did somebody who had a lower ranking get the seat which she says she is opted for? Yes. Do you want counsel to be engaged for you? Do you want counsel to be engaged, or will you make your submissions yourself? You want a counsel to be engaged?
You know somebody? You are from which place? Either. You know some lawyer here?
My learned friend Prithvish is willing to take it up.
He's a good advocate, you can, if you want, it is not that we have suggested, don't say that. He appears in such matters.
Please,
Already.
and please speak to each other whether the issue can be sorted out also, please make a, when do we list this? We know, please see whether something can be worked out. If it cannot be, we'll hear you on the merits of the matter. By the time they can also place their statement on record, how it happened.
What's mindset necessary?
Wednesday, we've already listed one KEA matter. Please implead the state government. Let us see, if as a matter of fact, you can iron it out without the state being there, we don't mind it. If that can be ironed out, that is well and good. Please make an it and give copies to Prithvish also. Yes, so-and-so learned counsel. Is yes. No, just to learned, the fourth respondent has appeared in person. He submits that he requires legal assistance as well. We therefore requested Shri Prithvish learned counsel to appear, to assist the court and to appear on behalf of the fourth respondent, so that the matter can be considered and appropriate orders can be passed. List on Wednesday. Please, if you want to implead the government, please do so. The petitioner is also permitted to implead the state government as a party to this writ petition.
My lords, I have one submission, my lords. My
Yes.
name has been wrongly shown, my lords, in the cause list. For respond number 2, my name is Suraj Nayak, my lords. It's SRAJ.
Yes.
It's SURAJ, my lords.
Show the correct name of the learned counsel appearing for R2 as Suraj Naik.
Much
Yes,
obliged. Obliged.
yes, implementing application can be allowed. 1 of 2025. Yes, is allowed and then say this.
Grateful, madam.
Yes. Cost title has to be amended. Please carry out the other implementing also and amend the cost title. Yes.
Pastor matter, number 8. Shri Paniraj Kashyap.
My lords, I'm filing the memo, my lords. My lords, I have prepared only one.
Please submit to the reference we permit to withdraw the petitioner wanted to pursue the matter before the reference.
Advance for the appellant. File a memo, withdraw the appeal. More reads as in view of the absent memo. Appeal is dismissed as withdrawn. Stop. Pending applications are closed.
My lords, liberty may be given, my lords.
Liberty.
Adalpu ಬರ್ದಿ. ಬರ್ದಿದ್ದೀವಿ ಸ್ವಾಮಿ. Liberty to approach reference court and
Please dismiss as withdrawn with the liberty as sought.
my lords, and court fee may be refunded.
The text is directed to refund releasable from.
Much obliged.
Number 11. Shri Prithvi Shamke.
Well, it's just requesting court to permit me to reread bylaw 21-2, which we have already done a couple of times. But my lords, I now, my lords, feel it.
Page number?
Page number 164, my lords, of the appeal memo. May I read, my lords? Lords, 21-2 I'm reading, lords.
Yes.
The seniority of the employees in each category shall be determined by order of merit in which they were selected for appointment to the cadre in question. It shall be subject with respect of teaching cadres. Lords, according to me, my lords, even this reading of close reading of this, my lords, has two aspects embedded in it. It says by order of merit, and then it says in which they were selected for appointment. Lords, my respectful submission is to the card. It has to be only in the professor cadre. The appointment to administrative next dean director, it has to be from the feeder cadre is only professor. Now, my lords, now the feeder cadre professor in that in view of this 21-2 has to satisfy these two conditions. That it has to be in that the cadre has to be determined by way of order of merit and they have to be selected. Now, my lords, this cadre of professor admittedly is not by way of selection. It's by way of promotion from associate professor to professor. Therefore, not that word selected for appointment to the cadre in question cannot be, my lords, in my respectful submission to the cadre of professor in question, because there is no concept of selection when it comes to the post of professorship. They've all got to professor only by promotion and not by way of selection. Secondly, my lords, the other word which says by order of merit, lords, there is no order of merit also, my lords, when they're promoted from associate to professor. Therefore, my lords, my respectful submission, when I reread it, my lords, according to me, it appears to me, my lords, and now, my lords, I have a couple of judgments which I passed on, your lordships, which says, my lords, that this reading has to be read to the order of merit as per the selection list when they selected. Now, my lords, this very particular clause fell to the consideration of this honorable court in two judgments of this honorable court. If I may pass on, my lords, where it was held, my lords, exactly similar words, my lords. Say, not similar, same words.
Your contention is that it should relate back to the initial selection
Yes.
to whatever post. What is the post?
They all entered to lecturer post. Please. Because here, my lord, feeding cadre does not, neither does it have a order, a merit order in its thing, nor is it a selection post. They all came by way of promotion. Therefore, my lords, now how this honorable court is considered. My lords, first of the judgment, if your lordships permit me to read. This was by a division bench, my lords, of which the honorable Chief Justice was part. That's the first of the judgment, my lords. These two, both the cases, three cases which I'm relying, the facts were, my lords, on the ground that when they both enter on the same appointed date, but when they report on a different date, how seniority should be reckoned. While they were addressing this issue, my lords, in the first of the case, may I read a couple of fact notes? Para 3, my lords, at page 2 of the first judgment, my lords. Just a fact, my lords, so that Para 3, the appellant and the third respondents were recruited to the cadre of associate professor in the same selection process. According to bylaw 14 of the Karnataka Institute of Medical Sciences, Hubli, when a post is filled by direct recruitment through open advertisement, the selection committee shall meet and examine the credentials of all persons who are to be considered for the post, and the committee shall prepare panel of names and recommend the name in the order of merit. But then, my lords, they discuss, my lords, how it was forwarded. Now, my lords, para 6, my lords. Internal page 5 of the judgment, my lords. May I read para 6, my lords? Bylaw 20 of the bylaws of the Karnataka Institute of Medical Sciences, Hubli, reads thus. It's 20 subclause 1. The chief administrative officer shall prepare and maintain the gradation list in respect of each of the categories published the same every year. If I may pause, notes, the same clause is there. Only the difference is dean and director should prepare the list. Here it is the COA host. The second subclause is verbatim the same notes. The seniority of the employees in each category shall be determined by order of merit in which they were selected for appointment to the cadre in question, subject-wise in respect of teaching cadres. In respect of non-teaching cadre-wise, seniority list will be prepared and published. It's exactly the same words like the bylaw before your lordships, notes. 21-2. This is 22 minutes.
In respect of non-teaching staff, cadre-wise seniority list shall be prepared and published.
Yes.
Yes.
Yes. The first 4 lines also, notes, which were being relied on, notes. The seniority of the employees in each category shall be determined the order of merit in which they were selected for appointment to the cadre in question, subject by in respect of teaching cadres. This is the very same proposition before us, in the present case. How honorable division bench, and the subsequent clause are also pretty much same like the present case. But since we're restricted to 21-2, I'm restricting.
You're only on 21.
Yes. Now, at page 7, after quoting the entire bylaw, clause 2, may I read that paragraph? Clause 2 quoted above specifically stipulates that the seniority of the employees in each category shall be determined by the order of merit in which they were selected for appointment to the cadre in question, subject-wise in respect of teaching cadres. Since the appellant and the third respondents were selected for appointment to the same cadre of associate professors, and since the third respondent was ranked above the appellant in the selection list prepared by the selection committee, the third respondent is entitled to be treated as senior to the appellant. The above provision is in conformity with the general principles of service jurisprudence. But what?
And third respondent were selected for appointment to the same cadre of associate professor. And since the third respondent was ranked, therefore, what is being considered is the seniority in the post of associate professor.
Please. But what is said, my lords, is they not this, since the appellant was selected for the same cadre of associate professor. Even in this case, my lord, they were recruited in the selection list. What I wish to submit here, my lords, is if I may read from the fourth line, since the appellant and the third respondent were selected for appointment to the same cadre of associate professor. Here, and the word is later on qualified by the selection list. I'll just take. And since the third respondent was ranked above the appellant in the selection list prepared by the selection committee, the third respondent is entitled to be treated as senior. In our case, the selection list was published between the appellant and everybody in question, my lords, when they were appointed in the same cadre of lecturer, my lords. So it is that selection list, my lords. They say that merit in that selection list is what, my
Yes.
lords, because it's the same bylaw, my lords.
What is the meaning of saying cadre-wise?
My lords,
Then that has to, you have to give a go by to the language of the rule and say that what is intended is not cadre-wise. It is the first cadre where there is a selection.
yes, but this is what the honorable, in my respectful submission, division bench has done, interpreted this.
In that case, the contention specifically is that
Yes.
they were appointed on the same date. In your case, that is not the case.
They were appointed on 29/5/2020.
Appointed to the cadre of professor on the same date.
It's
What we are considering is
Correct.
seniority in the cadre of professors. And to the cadre of professor, they were not appointed on the same date. This specifically is with regard to
associate professor.
appointment, how seniority is to be considered.
Please.
When two persons are appointed to the cadre, to a cadre on the same date. That is a question which is being examined here. Then the court says, if two persons are appointed to the cadre, which in the case is associate professor on the same date, then the order of merit in which they figured in the selection is to be considered. Yes.
Yes, that is,
No, absolutely. It cannot be. No.
yes. Now, second judgment laws, which I have. This is single judge's order. The third one is writ appeal over that, but I would like to not draw inference from this order. It's here also. At internal page 10 minutes, para 7.
Yes.
Yes. The learned counsel of the petitioner has raised the following contentions before the court. Firstly, according to the regulation 19, the rules and regulations, including bylaws of Karnataka Institute of Medical Science, Hubli, the seniority of the employees in each category shall be determined the order of merit in which they were selected for appointment to the cadre in question, subject-wise in respect of teaching cadre. Similar thing, para 8 minutes. Secondly, according to the selection list dated 11/8/2008, the petitioner was shown as more meritorious than respondent number 3. Therefore, in accordance with regulation 19 of regulations, which prepared the seniority list dated 2/1/2010, the petitioner should have been shown as senior to the respondent number 3. Para 12 minutes. The contention notes as is put forth now by the appellant here minutes at internal page 11. On the other hand, Mr. So and so, the learned counsel for the second respondent, Kims, had pleaded that according to the regulation 15 of the regulations, an appointment is said to take effect from the date of the employee report for the duty. That was the date of the report for duty, they were saying notes. And then para 15 minutes, these two regulations were culled out. Yes, notes. Now, para 17 minutes. Para 16 is what they've discussed previously, not para 17. Admitted in the selection list, the petitioner was shown as more meritorious than the respondent number 3. Therefore, while drawing the seniority list, the date on which the respondent 3 and the respondent joined their service is irrelevant for consideration. For according to Rule 19, the seniorities can be drawn only on the basis of merit list. Therefore, the learned counsel for the Kims and the respondents are unjustified in claiming that seniority list is legally valid as it is based on the date of joining of the service. Now, my lords. Para 19 minutes. Moreover, once a law laid down a criteria for drawing up seniority list, the criteria cannot be ignored. After all, the Kims cannot be permitted to flout its own regulations. Moreover, the joining of service is a fortuitous circumstance. Therefore, a fortuitous circumstance cannot be given precedent over the criteria of merit. Needless to say, an educational institution is wedded to the concept of merit. Although seniority is crucial in promotion based on seniority merit, but merit could not be ignored totally. Therefore, notes, they go ahead, notes.
19 would be against you. The institute can only go by their professed bylaws. If the bylaw says, the seniority is to be on the basis of merit in the selection to the cadre. That is all it can be. If there is no selection to the cadre, then it must be in the order of the first appointment. That is the basic principle of service law. When there is no other principle enunciated, then it is to be on length of service.
In my respective
because what we are considering is seniority.
Please, notes.
When there is some criteria provided for deciding seniority, then the criteria has to be followed scrupulously. If there is no criteria provided, and it is indicated that it is cadre-wise, then what must be the principle?
No, I understand,
Length
you're
of
also follow the
service.
rules.
Length
bylaw.
of service in the cadre.
Please, my respectful submission also was relying on the words as fortuitous circumstances. Of course, your lordship pointed out to me that I have not challenged the cadre rules, which says, because my lord, it's on the face of it, my lords, it's only from the date of, if we were to accept the case of the appellant, it is only from the date of professorship, my lords. It is unfair, my lords, for people who have entered the service together.
Who
And you
should
can
decide the fairness and unfairness of a service regulation?
It's therefore, my lords, what I'm submitting, lords, in my, of course, your lordships, I have a voice your opinion that the judgment one differs is what you're saying, lords. But according to me, lords, what the division bench judgment said was that you have to go back to selection, merit order in the selection list when they came together. Lords, in our case, they came together only in the first time, lords. Later on, they marched in different paths. Is my, of course, my lords, your lordships should, because that is, because the prima facie, my lords, it according to me.
Even if you were to challenge it.
Yes.
The difficulty is this, it's not for us, the courts, to decide what is fair or unfair. It is for the employer to say what should be the criteria on which a seniority is to be drawn up. And then the rule says it is the 5 senior most. Therefore, that seniority list, without a challenge to that condition at least, it's nothing that can be
See, in fact, my lords, when this thing was going on, the institution, my lords, has published a list, my lords, and actually I pointed out, following that, my lords, going back to the parent merit list, 2000, they withdrew it, my lords. Now, I'll point it to the statement of,
going by these rules, they cannot do that.
my lords, in fact, now in the statement of objection filed by the institution, my lords, there was also a discussion, my lords, which we did, my lords, that KCSI rules will not be applicable, is what the court also felt, my lords. But now in both the respondent number 3 is appellant as well as the state's respondent, the objections, both of them admitted, my lords, that until rules and regulations are published separately on seniority, it is the KCSI seniority rules that the constitution will follow.
Even if that is so.
Yes.
The CNR rules will create a problem because the CNR rule says 5 senior most professors. Therefore, who is senior in the cadre of professor? There's no rule anywhere which says that your full service-wise seniority is what is to be taken into account for the purpose of seniority of professor. All the seniority lists in all institutions normally are prepared cadre-wise. Otherwise, what is the requirement? There can be one list. Only one seniority list is required in each institution. It's not
It's only
so.
for the post of administrative post, it's not for the other.
Otherwise,
Yes.
there has to be seniority list. There is a concept of cadre-wise seniority.
Please.
Apparently, going by the seniority list, going by the CNR rules, what is intended is cadre-wise seniority. Therefore, you cannot say that unless there is a provision which I have not found in any.
May I only
any
take
service
lordships?
which says that the seniority in every cadre has to go back to the original date of appointment in the service. It's not the general proposition.
It's, may I just, the statement of objections filed by the institution, lords, that your lordships will find at page 206, my lords, of the appeal memo.
206.
Yes, lords.
Yes, this specifically is their case. To
Yes.
the cadre in question.
So what I'm trying to say is, lords, your lordships were saying there's nowhere rules that from the length of services was taken, because now, lords, they say, lords, in this para 18, lords, if I were to read on the bottom of the para 18, lords, on that particular page, further as your lordships get that, lords, on that page, para. Further, as per clause 20 of the bylaw, the provisions of the Karnataka Civil Service Act and rules framed thereunder are made applicable till new rules and regulations were framed. Further, as per clause 9, the provisions of the Karnataka Civil Service conduct rules are made applicable mutatis to the applicants. But further, lords, they also say that seniority rules shall be applicable. Lords, cases of seniority rules.
No.
Para 20, yeah, I will show you. Para 24, lords. At page 216, lords, para 24 starts. After lords, culling out clause bylaw 21 to which we read out, The next paragraph is, the above makes clear that seniority of the employees in a particular cadre is required to be determined based on the date of entry in the cadre in question. The entry in the cadre may be through promotion or direct recruitment or absorption from Health and Family Service Department. Bylaw 24 specifies application of other provisions of various rules framed under Karnataka Civil Service Act, including the seniority rules as stated in clause 2 of the bylaw 24. This para 26 minutes. Yes, minutes. I will read full. No qualms. Further, it is submitted that till date from 2013, the appointment to administrative post, the five senior most professors were considered. In view of the above, the contention of the petition is based and is not maintainable. Hence, for the above and said reason, the writ petition is not maintainable. Bylaws, minutes, and C&R rules were published in the year 2013, minutes. Now, minutes, para 26 minutes. They specifically say minutes. Para 26 minutes. It is submitted that averments made by the petition, the above paragraph is denied as false and baseless. Further, it is submitted that the provisional seniority list published by the circular dated so-and-so was withdrawn, as the same was not in accordance with the Karnataka government seniority rules 1957. Lords, why I am troubling the court with reading of this is, my lords, that, my lords, we cannot brush aside, saying that seniority rules of cases are not applicable to this case, where my institution admits that these rules are applicable. And cases are seniority rules, my lords, under section 5B, provides, my lords, when it's a direct post by selection and direct recruitment, it has to be by way of order of merit in the first merit list of selection, lords. This is what and this is also not case of the appellant notes in the statement of objections. They say that cases as seniority rules are applicable notes. I may just I just pointed that one bit of it notes. Page 226 in the last paragraph notes with it. It's the objections. Page 226 notes. It's the objections filed by the appellant here and was the respondent number 3 before the court will notes. Learned single judge. Let's at page 238 of the objections minutes. It's para 28 of the objections minutes.
Yes.
Yes, minutes, para 28 minutes. It's the appellant's thing. The combined merit list alleged to have issued by the KPC produced by petitioners when extra B is non-existent, invalid and appears to be manipulated. Therefore, no value and credence can be attached to the same. The petitioner's contends that he has served the institution for a long time and who has toiled for the institution relentlessly cannot be used as a yardstick to determine his eligibility to the administrative post in as much as the MCI, NMC rules, CNR rules, bylaws, and Karnataka government servant senior rules 1957 are binding on BMTF, where following the procedure for appointment to the administrative post is there. Now, cases are rules, milords. Seniority rules, milords. I will not bother, milords, with taking out that rules, milords. If I may just read that seniority rules. 5.1 of the seniority rules, cases are, milords, says, the decision regarding the seniority of direct recruits to a service or to a class of post shall be made by appointing authority at the time of their first appointment in one of the modes mentioned below. A says, milords, when the recruit, pardon me?
Class of posts.
Yes, milords. Yes, milords. Class shall be made when the recruitment is made on the on the result of a competitive examination. The order of seniority will be in the order of merit. B, milords. When the recruitment is made by selection, which is in our case, the order of seniority will be determined the order in which the candidates were arranged in order of merit by the appointing authority in consultation with the Public Service Commission or other authority making the selection.
Forever and evermore.
Pardon me, milords?
As the rule says, forever and evermore.
It is not, milords. I understand 2013 is what they came up with.
For the selection to the post or cadre, or at least to the class of post.
Yeah, that is the view.
You
No, this was an answer.
Initial order of merit by which you have selected and appointed to the first post. That cannot be the condition for your seniority till you retire from service.
But of course, our entire case is based on that, milords, the length of service and the order of merit, the first KPC selection. Otherwise, milords, what is the? This is just my submission, milords. What?
The first post, that is how it has to be done. Thereafter, there may be further qualifications required for further promotions. And if somebody who is senior does not have the qualification for the next selection, then the person who does have the qualification, whether it is promotion, selection, whatever, or the number of posts. Fortuitous, yes.
Yes, yes.
But then that is how it has to be. Otherwise, what is the meaning of cadre seniority at all? If you enter a post with a certain merit, you die with the seniority.
which you entered.
No, it's not for all posts. It's only for administrative posts. They say, I mean, I'm relying again going back to Ramchandra Rao's case, but they say
Among
you
the
should not allow, because it is not in my hand. We entered together. He got because he was biochemistry. There was vacancy that arose.
We understand the
Yes.
contention
That's
and the arguments were extremely, we will say that the arguments absolutely in a case of this nature, nothing further could have been argued. You've argued extremely well.
So I just try my best. If you believe that, that thing that ought to be interpreted like that.
We understand the grievance also.
Yes.
There is a grievance.
Yes.
But then
Because it's not only
sadly-
the date of appointment of professorship, no, it was also the merit which I qualified when I entered.
But then that is a difficulty. That's difficulty. We understand the
Yes.
situation, an author petition. Who is a better merited candidate,
It's like,
having the contention that he is entitled because, and somebody who's just been, but then it again, there is also another aspect to it. It is an administrative post. And for the administrative post, the merit of the doctor in the medical field may not be what is actually required also.
I only would request to consider these judgments also that I've relied on, my lords.
Because everything
And also
is-
Ramchandra Rao's distinction, also, which we heavily rely on. Yes.
Yeah.
Very grateful for a very patient hearing, my lords.
I think that
Yes, yes, yes. Grateful for a very patient hearing.
What that.
That the court only has distinguished.
Because four, they specifically, my lord, state what the grievance is. That is of the feeder cadre when they entered service, whether it's date of joining or the merit. That was the question, my lord, in the second judgment also. Paragraph 16. That is also in 2015 SEC online.
bare perusal,
Adamali Nadaf was a state of law.
Second.
a bare perusal of the two provisions.
Yes, they bear per you. That would be. But in the third judgment, I have suffered that judgment that too. So that there the paragraph would be para 16. The question now arises. I'm sorry, that's the other paragraph.
Paragraph,
It's the question that would now arise, but there's one other. I just. Oh, I'm sorry. Para 11. It's a long paragraph. Internal page 19 last. Whether it's the date of joining or the merit in the select list, what is the relevant date? Now, let's, for that cadre in question, they said it's the merit. They did not say throughout for promotion. Let's just on the flip side, if their argument is to be accepted. Now, if 100 of us are selected and all of us have to be given professorship on the same day, then whether there is sufficient number of the cadre strength in each of those subjects, whether it's available or not, everybody can't be given the same date of promotion. That would be in violation of the MCA because each cadre will have its own strength. Orthopedics may have 5 and 5 may be filled up. Therefore, to give those who are not, even though there is no vacancy, to give that date would be violence to the MCA regulation.
anything further?
We have supported the petitioner, in the appellant in the writ petition by filing an objection.
This is how you're
Yes.
fixing seniority in all the cadres.
Yeah.
Lee in this, he has supported me. 2 others here opposed me vehemently.
Yes. Reserved.
Very
Great.
good.
ಬರಲ್ಲ ಮೋಸ್ಟ್ಲಿ ಬರಲ್ಲ. ಯಾಕಂದ್ರೆ ರಿಸರ್ವ್ ಆಯ್ತು ಚೇಂಬರ್ದು ಒಂದು ಆದ್ರೆ ಮೋಸ್ಟ್ಲಿ ಬರಲ್ಲ. ಮುಗೀತಲ್ಲ ಇದೆ ಒಂದು.
ಇರ್ಲಿ ಬಿಡಪ್ಪ.
Final hearing ಇತ್ತು. ಪರವಾಗಿಲ್ಲ. ನಾವೇ ಕೇಳಿ ಡೇಟ್ ಕೊಡ್ತೇವೆ.
ಬಿಡ ಯಾವ್ದು ಇರ್ಲಿ ನೋಡೋಣ.
ಇಟ್ಟಿ